This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, and this is our final episode of the Delphi trial. So, we are going to get through quite a bit today. It's going to be a bit of a longer episode. We've got jury instructions. First, they're going to discuss jury instructions. Then they're going to come back, do closings. So, if you remember, we left off where the state and the defense just rested. Judge Gull sent them home for the evening, and now they're going to talk about jury instructions. So, that's up first. Then we're going to go into the next day where they go into closings. And then we will have the final jury instructions read to the jury. They're going to be charged with those instructions and then sent off to deliberate. We will read the verdict and the sentencing as well because I figured let's do it all at once. It's going to be a long one, but that's okay. All right. So let's begin where we left off, which is, like I said, the state and the defense both rested in their cases. She sent them home. Judge Gull sent them home for the day and for the afternoon, I should say. And the rest of the afternoon, they're going to argue or discuss, I should say, just discuss what they want for the jury instructions here. Okay, so let's start where we left off. The bailiff says, everybody all rise, and then the jury leaves. The court says, you may be seated. I did receive, Mr. Rozzi, your proposed jury instruction. It looks like you also sent that to the state. Have you had the opportunity to review the proposed jury instruction? Yes, I have, Judge, says Mr. McLeland. The court says, and, well, go ahead, Mr. Rozzi, on your instruction. Mr. Rozzi says, Judge, I offered up that instruction. I think, obviously, it goes to the issue of the jury being the credibility of the statements made by Mr. Allen. I understand that, first of all, that language is pulled straight from the Stranger case. I thought that was the name. I think I cited that at the bottom of the instruction. And I understand there's another instruction. One of the patterns is that the jury is to determine the credibility of the witnesses, but in this case, because we have this unique circumstance that involves these incriminating statements, and that there is case law that discusses the two-part test, the first part of which we've already been through, I do think it's appropriate that the defense be able to, I guess you could use the word highlight, or place emphasis, maybe is a better phrase, on the jury's task with regard to dealing with these incriminating statements. So that's what I'm asking the court to do. Thank you. The court says, Mr. McLeland. McLeland says, Judge, the state is opposed to that instruction. There's an instruction already talking about credibility of the witnesses, and I think that encompasses that. I read over the Stranger case briefly once I got to the email. I think actually there's an additional instruction in the Stranger case that, why is that sick? I don't know. Isn't that what he was calling it? Stranger case? I'm confused why. Maybe it's not the Stranger case, but something else, but he keeps referring to it as that. I don't know. I'm confused. He says, I read over the Stranger case briefly once I got the email. I think actually there's an additional instruction in the Stranger case with the instruction that Mr. Rozzi proposed. I may be reading the case wrong, but I think in the Stranger case, they also put in there that the court has ruled that those confessions are admissible. And there's another part of I'm trying to find it. Yeah, that part, the court the court had determined that the confession was voluntary and not proper. I think that was in addition to the Stranger case, or the instruction from Stranger that Mr. Rozzi submitted to the court, or Stranger, sorry. Stranger, I don't know. Maybe he's saying it wrong. But again, the state's opposed to it. If the court is going to allow it, I would ask them to put the whole instruction from Stranger in there to let the jury know that the court did find that those confessions are voluntary and admissible. But I think the instruction is in the jury instructions now talking about credibility of witnesses. And I'm sorry, I didn't bring the instructions up with me, Judge, but there is a certain instruction that talks about the credibility of witnesses and how it's up to the jury to judge those credibility of witnesses and statements those witnesses made. I think that's sufficient to inform the jury, Judge. The court says, is this an actual instruction or just dicta from a case? Mr. Rozzi says, it is not, Judge. We'll move to withdraw. We'll move to withdraw. Court says, oh, okay. Mr. Rozzi says, we'll move on. Never mind, she says. Mr. Rozzi says, thank you. The court says, so I'll show that it's been withdrawn. I did receive from my assistant the pattern instruction on the defendant did not testify. Let me find it here. And it was the pattern, and it states no defendant may be compelled to testify. A defendant has no obligation to testify. The defendant did not testify. You must not consider this in any way. So if you want me to give that instruction rather than the instruction I provided to counsel, I'm happy to substitute them. Baldwin says, I will. Court says, out. Mr. Baldwin says, I'm sorry, Judge. I think we'll stick with what's there. The court says, the instruction I've provided? Yes. To you. Okay. Yeah, says Baldwin. The court says, so anything else about instructions? We've already settled order of argument, the time of argument. I'll just trust that you will monitor your time appropriately. Remember, speaking of time, Mr. McLeland said he was going to try to make it 2 hours, but then he kept saying, well, what if I go over 2 hours? I don't want you to cut me off. So he basically kept the court and Mr. Baldwin, Mr. Rozzi, Ms. Auger, all of the attorneys thinking that Mr. McLeland was going to talk for 2 hours or more about this in his closing. Keep that in mind because it's going to be really short, actually. So anything else about the instructions? We've already settled the time to monitor your time appropriately. We probably will take a break after the state does its first final argument and then come back to defendant's final argument. And it kind of just depends on what time we're at, where we're going to have to break for lunch before the state presents its rebuttal final argument. I just don't know where we're going to be at. Anything else that we need to talk about on the record, Mr. McLeland? No, Your Honor. Thank you. Mr. Rozzi? No, Your Honor. Mr. Baldwin says, Judge, I actually have something, just 3 very brief offers of proof related to, of course, the third party suspect, just in the event that there's a conviction. I don't know why they didn't come. It's probably there were 2 inmates, one named Reese Davis and one named James Haas. Reese Davis is at Newcastle. McLeland cuts him off and says, Judge, I hate to cut off Mr. Baldwin, but I'm going to object to this. This is more appropriately done in their case in chief. They've rested at this point. This is not appropriate for an offer of proof at this point. The judge said, or the court says, you didn't subpoena them or have me transport them? Well, says Mr. Baldwin. Mr. Rozzi says, I was just telling him that. The court says, okay. Mr. Baldwin says, I don't know that Brad has done that. The court says, oh, okay. Mr. Baldwin says, well, okay, then that's fine. Elvis Fields was properly served a subpoena to appear here. He failed to appear. I would ask for an arrest warrant for Mr. Fields. I'm going to repeat that. I would ask for an arrest warrant for Mr. Fields. Well, if my spit was found on the girls and I had a good reason why, would I be in trouble? That's that guy. So he did not appear to testify for the defense in this case. I wonder why, but he was pressured not to by someone. Mr. McLeland says, Judge, my understanding, I don't know that I have a role in this aspect of it, but my understanding, an arrest warrant is to order him to appear and to get him to appear here. Now that they've rested their case in chief, I'm not sure what the point of an arrest warrant is. Because he broke the law, he was supposed to be there, but he didn't go. That's the point of it. There's consequences when you break the law. but apparently not in Delphi. And in Delphi, you actually can be just convicted of double homicide even when you're innocent. So I don't know. Their rules are a little backward. He goes on to say, to bring him here for what? To ask him why he didn't appear, I suppose. But at this point, they've rested, Judge. So I don't know that the issue of a search warrant is going to effectuate him showing up, or an arrest warrant, sorry, is going to effectuate him showing up for the subpoena. Mr. Baldwin says the offer of proof, Judge, as I just did in a trial in August, can be done at any time. In that case, it was done after we had rested just for convenience of everybody, so the jury's not being bothered and so forth. And we did an offer of proof after the fact. And that's what Mr. Fields would have been here for, is an offer of proof after that fact. That's what I was going to have him here. Had he been outside, I would have said, here's my phone number, call me, and then we'll know when the trial is over, you're gonna come here and testify. And so I think it's proper for him. I mean, he's got a valid subpoena, he was properly served, and he ignored this court's order so to appear in court. The court says, and is the offer to prove anything different than what you provided to this court at the August hearing with Mr. Fields? Mr. Baldwin says, well, that I don't know because I was going to put him on the stand, this guy. So, having deposed him and so forth, who knows what he would have said on the stand. That's why I was bringing him. The court cuts him off because he can't get a sentence out. And she says, well, you have to know what somebody's going to say for a legitimate offer to prove. That is, that if the witness was called to testify, they would state A, B, whatever, C, D, E, F, G. Mr. Baldwin says, well, that's if I do it, but if he gets up on the stand and does it, that's different. I mean, if he gets up on the stand and says, yeah, I know who Brad Holder is, and I know that, whatever he might say, that would be on him. If I'm saying, then I would have to be, as an officer of the court, stating that what I think he would say should he testify based upon what he's already stated. But in this case, I wanted Mr. Fields to get up on the stand, answer some questions, and see what he said, which I think is proper, and if this were a trial, that's exactly what would have happened. The court says, well, it seems like we're all talking in circles. You're asking me to issue a warrant for an individual for their arrest to be brought before the court to be found in contempt of court. Yes, says Baldwin. The court says, for failing to honor a subpoena when I've already ruled that he would not testify as a third party suspect because, again, the defense has failed to provide the nexus from all of these individuals. Her and her damn nexus, which is so clear to everybody else but her. You provided a nexus of them to each other, but not them to this crime. How about Abby was dating Logan Holder, the son of Brad Holder? It takes 2 degrees of separation to find the nexus. Not that hard. Mr. Baldwin says, right. Court says, so without the nexus, there's no basis in fact. Baldwin says, and of course, I agree to disagree. The court says, absolutely. With you, says Baldwin. And the court says, and you've made your record. Mr. Baldwin says, but an offer of proof, Judge. Yeah, he was not allowed under your order to testify in the trial with the jury sitting over there. He is allowed to get up on the stand and answer my question, and who knows what he might say in relationship that could have opened the door to, for example, if he said, okay, yeah, I changed my mind, I actually was there, but I didn't participate in it. I mean, but here's my excuse about the gum spitting on, if my spit's found on the girls, here's what I meant by that. I was there, but I didn't, but we don't know what he would have said. That's the whole purpose of him coming in to testify, was to do that outside the presence of the jury. He didn't do that. He didn't appear. Anything else? Says Judge Gull. This is the response of like a mom when a kid is like, but mom, come on, I really want to go to so and so's, and gives like this whole long winded explanation as to why they should go to so and so's when really they're grounded or whatever. And that not like that ever happened in my life. I was grounded like most of my high school years. But anyways, so it's kind of like that, and then you give the kid gives all these reasons, all these great reasons you've prepared in your room quietly studying and waiting to like talk to your mom and say all these reasons why you should go to this party, because even though you're grounded, because all these good reasons. And your mom just looks at you and goes, yeah, anything else you want to say? And you know your answer is you're still grounded and you're still not going to that party. That's what this court just did to Baldwin. Anything else? No, Judge, thank you. All right. Will we be prepared and ready to go promptly at 9 o'clock? Mr. McLeland says, yes, Your Honor. Mr. Rozzi says, yeah, that's fine. Thank you. So Rozzi and McLeland are doing the closings, hence why they were on the thumbnail. The court says, thank you very much. And are you doing closing? Thank you very much. We are in recess. Jody, you can go off the record. So now we come back on the record. It is now November 7th, 2024 at 9:05 a.m. The court says, all right, well, good morning, ladies and gentlemen. We are back on the record in the state of Indiana versus Richard Allen. I'll show the defendants here in person with counsel. The state's here by the prosecutor and his deputies. All of the members of the jury have reassembled. Are we ready to do closing arguments, Mr. McLeland? Yes, Your Honor. Mr. Rozzi? Yes, ma'am. Okay, anything we need to talk about before we bring in the jury? No, Your Honor, says McLeland. No, ma'am, says Rozzi. The court says, and just a reminder, ladies and gentlemen in the audience, again, I appreciate yesterday you were very quiet. I would appreciate that continued compliance. There's a lot of officers in the back of the courtroom that will not hesitate to tap you on the shoulder and ask you to leave if you cannot remain silent throughout the course of the proceedings. It's important that the jury pay attention to the attorneys in the well of the courtroom and not be distracted by noise or commotion out of the audience, so please maintain your composure. Gentlemen. The bailiff says, all rise. Jury enters. The bailiff says, thank you. You may be seated. The court says, thank you, gentlemen. Well, good morning, ladies and gentlemen. It's nice to ease you back this morning, or see you back this morning. I don't know. It's a spelling error. I hope you had a pleasant evening. Again, as we parted company last evening and you had access to your phones for purposes of communicating with your family and checking your work email, I would ask you the following, again, set of questions. Ladies and gentlemen of the jury, have you read, seen, or heard any media accounts concerning the case? All responded in the negative. Have you discussed this case with anyone? Nope. Have you permitted anyone to discuss this case with you? All say no. Have you conducted any research into this case? Nope. And finally, has anybody persisted in attempting to discuss this case with you? All jurors respond in the negative. The court says, all right. Again, ladies and gentlemen, I thank you for your continued compliance with the court's directives. As I told you yesterday when we broke, you've heard all of the evidence in this case, and the next step in the proceeding is argument and instructions, after which you will retire to deliberate. The way that we'll be presenting the balance of the case to you is as follows. You now have in your possession now a copy of the court's final instructions. I'm going to read the first dozen or so pages of those instructions. Those are the case-specific instructions that deal directly with Mr. Allen, the charges that were filed against him, the statutory elements, and definitions that go with that. Once I'm done with that, the attorneys will present their final arguments. Since the state bears the burden of proof, the state is entitled by law to both open and to close the final argument, and in between, you will hear the defense. The hope is that as you listen to the attorney's final arguments, you already have a very specific framework of the law at your disposal as you listen to the arguments of counsel. Once they're done with their arguments, I'll present the balance of the instructions to you. Those are at the back of your packet. Those are at the more general instructions on how to deliberate and weigh the evidence that you've seen. Again, you have copies of these instructions and you may follow along if you wish. And I'll just tell you in advance the arguments are going to be rather lengthy in time, and obviously, no, they're not. And obviously, I'm going to expect you all to sit there for 6 hours or 5 hours or however long it takes, so we will be taking a break. When the state has concluded with its final argument, we'll take a break. The defendant will present his argument and we'll take a break, and then the state will present the balance of their argument and we may be taking a break. It kind of just depends on where we're at time-wise, so just so you know, we will be taking breaks. Don't panic. Think you got don't think you got to sit over there all that time. Again, I am required by law to read these instructions to you, and you may follow along with them if you wish. It is the duty of the court to instruct you in writing at the time concerning the matters of law necessary for your information in giving your verdicts. Since this is a criminal case, the Constitution of the state of Indiana makes you the judges of both the law and the facts. Though this means that you are to determine the law for yourselves, it does not mean that you have the right to make, repeal, disregard, or ignore the law as it exists. Don't ignore the law, people. The instructions of the court are the best source as to the law applicable to this case. In deciding this case, you must determine the facts from a consideration of all the evidence and the law from these instructions and find your verdicts accordingly. All of the law in this case has not been embodied in any one instruction. Therefore, in construing any single instruction, you should consider it with all others. This is a criminal case brought by the state of Indiana against Richard Allen. This case was commenced when informations were filed charging the defendant with count 1, felony murder, a felony, count 2, felony murder, a felony, count 3, murder, a felony, and count 4, murder, a felony. Why did they get to do multiple charges for the same thing? I don't get how that's allowed, but that's what they do. Or to have variations, like in the Karen Reed case when they had the variations of degrees of guilt. It's just confusing. And it gives the jury more opportunities to convict. So it gives the state more options. Like when there's 3 options that say guilty, or 2 options that say guilty or not guilty, that's easier. But when you have all these other options and you have to determine the levels of guilt and all that, it makes it so complicated for the jury, and no one explains any of that to them. So it's just, I don't know why they're allowed to do that. So those informations omitting formal parts read as follows. Count 1, on February 13th, 2017 in Carroll County, Indiana, Richard Allen did kill another human being, to wit, Abby Williams, while committing or attempting to commit kidnapping. Count 2. On February 13th, 2017 in Carroll County, Indiana, Richard Allen did kill another human being, to wit, Libby German, while committing or attempting to commit kidnapping. Count 3, on February 13th, 2017 in Carroll County, Indiana, Richard Allen did knowingly or intentionally kill another human being, to wit, Abby Williams. Count 4, on February 13th, 2017 in Carroll County, Indiana, Richard Allen did knowingly or intentionally kill another human being, to wit, Libby German. The crime of murder is defined by law as follows. A person who kills another human being while committing or attempting to commit kidnapping commits felony murder, a felony. So that's how they distinguish it. It's the kidnapping part, but there was no proof that he was trying to kidnap them. So how did they even get to kidnapping? So it's the kidnapping part that makes it a felony. He attempted to kidnap them. What proof is there of that? Why did it go from murder to felony murder? Because it didn't come until later, after he was already indicted for a while. It didn't come till it was the felony murder charge. So I don't know. Continuing on with Gull's instructions, she says, before you may convict the defendant, the state must have proved each of the following beyond a reasonable doubt. 1, the defendant, Richard Allen, 2, killed 3, Abby Williams, 4, while committing or attempting to commit kidnapping. Again, where's the proof of the kidnapping? When did this even come into the trial? at all. They're charging him with kidnapping or a charge that goes hand in hand with kidnapping, yet there's no evidence that he tried to kidnap these girls, which is defined as a person knowingly or intentionally removes another person by force or threat of force from another place to another, from one place to another. So that's what kidnapping means. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state did prove each of these elements beyond a reasonable doubt, you must find the defendant guilty of count 1, felony murder, a felony. The crime of murder is defined by law as follows: a person who kills another human being while committing or attempting to commit kidnapping commits felony murder, a felony. Before you may convict the defendant of count 2, the state must have proved each of the following beyond a reasonable doubt. 1. The defendant, Richard Allen. 2. Killed. 3. Libby German. 4. While committing or attempting to commit kidnapping, which is defined as a person who knowingly or intentionally removes another person by force or threat of force from one place to another. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state did prove each of these elements beyond a reasonable doubt, you may find the defendant guilty of count 2, felony murder, a felony. The crime of murder is defined by law as follows: a person who knowingly or intentionally kills another human being commits murder, a felony. Before you may convict the defendant of count 3, the state must have proved each of the following beyond a reasonable doubt. 1. The defendant, Richard Allen. 2. Knowingly or intentionally. 3. Killed. 4. Abby Williams. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state did prove each of the elements beyond a reasonable doubt, you may find the defendant guilty on count 3, felony murder, a felony. The crime of murder is defined as by law as follows: a person who knowingly or intentionally kills another human being commits murder, a felony. Before you may convict the defendant of count 4, the state must have proved each of the following beyond a reasonable doubt. 1. The defendant, Richard Allen. 2. Knowingly or intentionally. 3. Killed. 4. Libby German. So the only difference between this is that there's not the kidnapping thing. So stupid. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty. If the state did prove each of the elements beyond a reasonable doubt, you may find the defendant guilty of count 4, murder, a felony. Intentionally or knowingly is defined by statute as follows: a person engages in conduct intentionally if, when he engages in this conduct, it is his conscious objective to do so. A person engages in conducting knowingly if, when he engages in this conduct, he is aware of the high probability that he is doing so. Direct evidence means evidence that directly proves a fact without an inference and which, in itself, if true, conclusively establishes a fact. Circumstantial evidence means evidence that proves a fact from which an inference or the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts. It is not necessary that facts be proved by direct evidence. Both direct and circumstantial evidence are acceptable as a means of proof, where proof of guilt is by circumstantial evidence only. It must be so conclusive in character and point so surely and erringly to the guilt of the accused as to exclude every reasonable theory of evidence. The credibility of a witness may be attacked by introducing evidence that on some former occasion the witness made a written statement, in former testimony testified or acted in a manner inconsistent with his or her testimony in this case. Evidence of this case may be considered by you in deciding the value of the testimony of the witness. Under the law of the state of Indiana, a person charged with the commission of the crime is a competent witness to testify in his own behalf. However, a person charged with the commission of a crime cannot be compelled to testify and is under no duty or obligation to testify. The fact that the defendant did not testify raises no presumption of any guilt or of any kind against him. It shall not be comment upon, referred to, or in any manner considered by the jury in determining the guilt or innocence of the defendant. For purposes then of the initial argument, Mr. McLeland. So her last point, it shall not be commented upon, referred to, or in any manner considered by the jury that he did not testify. I like that you can't even comment on it. Like, put it out of your mind. The fact that he didn't testify, just forget that little tidbit of information. But yeah, so those, I guess she did read the jury instructions. I think we might get them a second time around. I don't think I'll read them a second time because I have here where she charges the, yeah, well, we'll get to that. All right, let's continue on. All right, so Mr. McLeland is about to get into, whoops, I moved my page here. Mr. McLeland is about to get into his closing arguments. Again, this is his first round, then we'll have defense, and then he'll go again. So Mr. McLeland says, "Thank you, Your Honor. Ladies and gentlemen, February 13th, 2017 is a day that this community will never forget. It's the day that Abby Williams and Libby German went to the trails for a walk and never returned. The day that both of them were murdered by Richard Allen. 3 weeks ago, 3 weeks or so ago, we told you that we would give you the evidence to convict Richard Allen, and the state has done that. It's been a long trial, and so I want to go over a few of those pieces of evidence with you today. Real quick, I'm going to post a poll if it's not already posted already by the time that this video gets posted. I'm going to ask you guys who have read along with me if you think that the state proved its case beyond a reasonable doubt. So keep that in mind for the poll on my community tab. We're going to talk about that. We're going to pull you guys on that because I'd like to know what you guys think before I give my opinion. All right, and the state has done that. It's been a long trial, and so I want to go over a few of those pieces of evidence with you. This all started on February 13th of 2017. Becky Patty was at home with Libby German and Abby Williams. And Abby Williams had spent the night before. Both Abby Williams and Libby German were home. I'm going to stop saying both names. I'm doing it because of the initials. I'm just going to say Abby and Libby. Both Abby and Libby were home off of school that day and playing around the house, playing with the new puppy that Libby had gotten not long ago. Abby and Libby had the idea to go to the trails. They asked their grandma Becky if they could go, and Kelsey offered to give them a ride. The last thing that Libby said to Becky was, "Grandma, it'll be okay." And they headed to the trail. On the way to the trail, there on Snapchat, Libby was posting pictures. The plan was then for them to go on to the trail and then for Libby's dad, Derek, to pick them up later that day. Kelsey dropped them off at about 1:48 p.m. We can tell that from the phone data that Libby German's phone is unplugged at about 1:48, and shortly after she's dropped off at the trail. Around 3 p.m. that afternoon, Derek arrives at the trail to pick up the girls, but he can't find them. He walks the trails. He goes to the Monon High Bridge. He calls Libby German's phone several times. Can't find the girls. At 3:30, Derek calls Becky and tells her that he can't find the girls and the families get involved in the search. Anna Williams is contacted. No one can find the girls. Sometime after 5, the family calls law enforcement to report the girls are missing. We heard from Mitch Catrone, the first one to respond. He took the call. He was at the station when the call came in. He goes to 625 and proceeds down the private drive to look for the girls around the Monon High Bridge. He continues down the drive and goes to Brad Weber's house, and he speaks to Brad Weber. Brad Weber says, "Yeah, look around my property, look all you want, no problem." He gives them a switch, a quick search. He gives them a quick search around the property, but finds nothing. Other law enforcement join in, the fire department joins in, family members, community members join in for the search, and the search goes till 2 a.m. on the 14th. And you heard from several of these searchers and the law enforcement officers that at this point, no one is looking for two dead bodies, they're looking for two girls. No one thought anything bad had happened to Abby and Libby. That doesn't happen around here. It's a small community. These kinds of things don't happen. The search resumes on the 14th around 7 a.m. and it continues around noon until Pat Brown calls Steve Mullen and notifies him that he found the girls, that he found Abby and Libby. Deputy Giancola was the first on the scene. When he arrived at the cemetery, he made his way down to the creek. He met with Pat Brown and other searchers and they pointed to clothes in the creek, clothes that they had found, a shoe, a tie-dyed shirt. When he was speaking to the members at the creek, they pointed back towards the cemetery to where the bodies of Abby and Libby were located. Deputy Giancola testified that he walked right past them and wasn't even able to see them from his vantage point, that they were hidden, trying to make it seem like the sticks were and they were placed in that location to be hidden when I don't think the sticks were not used for that. It seems they were more of in the shape of runes and things. But this is the state's argument to make it look like they are just hidden and can't be found. You can walk right past them. He walked to where the bodies were and he secured the scene. He didn't get too close, but he observed that both Abby and Libby were dead, that their necks were cut. And remember this point for later, that he testified that the Carroll County Sheriff's Department carried 9mm firearms, not 40 caliber. Once Giancola found the bodies or located the bodies, he called other law enforcement. Crime scene technicians arrived and they started to process the scene. They started to document the scene. They started to take pictures. They started to collect evidence. Now, those pictures, these next pictures are hard to see, but this is what they saw. So obviously, he's showing some kind of visual aid in the background. As they processed the scene, they did so carefully, or maybe not. These next pictures, yeah, it sounds like he's referring to some slides that he's showing them on the scene or something. So these next pictures are hard to see. As they processed the scene, they did so carefully, addressing one girl and then the next, carefully documenting everything they found. They collected a phone that was underneath a shoe underneath the body of Abby Williams, a phone that was covered in leaves and water and dirt. They also, of course, he's got to say that because that was the argument in Cecil and Bunner's response to Stacey Eldridge's bombshell testimony that somebody was handling that phone, doing things to that phone that had to have been manually done. Mr. McLeland continues and says they also collected a bullet that was found between the bodies of Abby Williams and Libby German. The phone was immediately taken and processed. The information from the phone was extracted. From the phone, they found a video, the last video on the camera roll. The state published Exhibit 200, which was probably the bridge guy video there, if I were to guess. Mr. McLeland says we were able to determine from the download of the phone that the video was taken at 2:13 p.m. Yes, that is the bridge guy video. On February 13th, 2017, the video shows the moment Abby and Libby were kidnapped, the moment they were forced down the hill by the guy in the video, bridge guy. You can hear the fear in their voice, see the fear in Abby Williams' face. I don't think you can see her face. He forced them down the hill with a gun he used to intimidate them, to scare them into doing what he wanted them to do. He used them to let them know that if they didn't comply, he was going to use that gun. You hear in the video, guys, in the racking of the gun, and then down the hill. We know there's a gun involved from the girl's own words. That be a gun. That's not what they said. Said something like, "We gotta that's the way down," or something like that. Can't remember the exact words, but it's definitely about they have to go down that hill unless they go back the other way. Those were their only options. So it was something about them going down the hill because that was the only way out. We also know there's a 40 caliber bullet found at the crime scene between the bodies of the girls, and so law enforcement takes that video and they enhance that video. But before they do that, they take screenshots in an attempt to get a better look at Bridge Guy. These screenshots are in sequential order. The first one, you don't see Bridge Guy. The very next frame, you do. He continues to follow Abby Williams, and something in Libby told her that she needed to film this, that she needed to get out her camera and record this. Dude, you're totally speculating what was in her mind. And where they said that Abby's face was in fear, when she never looked like she was afraid in that video, in the Bridge Guy video, that she's on it for a few seconds. You don't see her face scared. It was just a normal everyday. They were just trying to walk. She's walking on the bridge, focusing on not falling. And once the video was sent off and enhanced, this is what we found. He publishes some more videos. Mr. McLeland says the enhanced video gives you a better image of what Libby German recorded. The fact that Abby Williams was being followed by Bridge Guy, the fact that he told them to go down the hill, the fear in Abby and Libby's voice, the fear in Abby's face. And so law enforcement began to interview people that were on the trail that day. They talked to Rayleigh Voorhees and Bree Wilbur. Heard from Bree Wilbur that when she came onto the trail, she began at the High Bridge or the Freedom Bridge, and she took a picture there at 12:25 p.m. That's when they got off the trail, and they walked on the trail towards the Monon High Bridge. And when they got to the Monon High Bridge, it was about 12:43 p.m., and she took a picture when she got there. And then they turned around and walked back towards the Freedom Bridge. And as they did, they talked, they took pictures, and near the end of their journey, they took a picture at a bench at 1:26 p.m. After that, Bree Wilbur testifies that she sees a man on the trail. You heard from Rayleigh Voorhees and Brad Wilbur. They both see the same man. They describe him as a creepy man, a creepy guy. He looked angry. He didn't respond or make eye contact like he was walking with a purpose. We then heard from Betsy Blair. She was walking the trail that day and she had on a Fitbit, and she told you that she went to the trail once, left to use the restroom, came back, walked to the trail or walked to the Monon High Bridge. And when she got there, she noticed a man on the first platform on the bridge. She arrived at the trail around 1:45 and was there until 2:15. She arrived at the Monon High Bridge around 2 o'clock. She testified she entered through the Mears entrance and went right to the Monon High Bridge. And again, as as she gets there, she sees a man on the bridge on the first platform, and she testified that he seemed to be watching for someone. As she turns around to walk back towards the Mears entrance, she passes Abby Williams and Libby German. Then you hear from Sarah Carbow, who she was driving at 300 north at around 4 p.m. She sees a guy walking down the side of the road who was muddy and bloody, looked like he had just slaughtered a pig. I don't remember her ever stating those words. Do you guys remember her saying that on the stand? Because I sure don't. So he totally put that in there on his own. He avoids eye contact. His head is down. His hands are in his pockets. All the people interviewed that you heard from give you a little bit different description of who they saw on that trail that day, but they are adamant that the person they saw was Bridge Guy. Bridge Guy from the video was from Libby's phone. There's no doubt in their mind Bridge Guy who kidnapped Libby and Abby. Then we heard from Steve Mullen, but nobody ever, that's the biggest problem with all of these witnesses. So you're claiming that Richard Allen is all of these witnesses throughout this entire timeline, but he told you he was gone way before that. He's always been consistent about the time he left. They tried to change it on him in interviews, and he said, "No, I left around this time." So he's already gone by like 1:30. And the crime supposedly happened after 2 because the last video on her phone was 2:13 or whatever it was. So it happened sometime after that. And so Bridge Guy would have to be Richard Allen would have to be Bridge Guy, which they've never established. Not once. Not one person has said the person that I saw that day is the man sitting at that table right there. That's a big problem. No one identified him as Bridge Guy. But everybody says or claims Bridge Guy is the guilty party. Yes, we all agree Bridge Guy is the guilty party, but Richard Allen has never been proven to be Bridge Guy. He avoids eye contact. His head is down. His hands are in his pockets. All of the people interviewed that you heard from gave a little bit of a different description of who you saw on the trail that day, but they are adamant that they are adamant the person that they saw was Bridge Guy. Bridge Guy from the video from Libby's phone. There's no doubt in their mind Bridge Guy who kidnapped Abby and Libby. Then we heard from Steve Mullen, who viewed the Hoosier Harvest Store video. He was able to observe Kelsey's car, Betsy Blair's car, Sarah Carbaugh's car, which confirmed the time that they were on the trail. Kelsey German passes the Hoosier Harvest Store headed towards the Mears entrance at 1:49 p.m. Betsy Blair is heading back to the trail for her second trip at 1:46 and 20 seconds. And then she's leaving at 2:18, and then Sarah Carbaugh's vehicle is seen at 3:56. This video confirmed the times that those witnesses testified about when they were there on the trail and when they saw Bridge Guy. The phone found at the scene was then further examined by First Sergeant Christopher Cecil. He did an extraction of the phone and a full analysis of what was found. He was able to locate health app data, Snapchat information, location data, more information about the video, and from this information, we know that Abby Williams and Libby German got to the trail around 1:48 p.m. And we know from each time that Libby German logs onto Snapchat that it gives a GPS location of where she's at. And First Sergeant Cecil testifies they will track that as they go down the trail towards the Moden High Bridge, and the health app data confirms that there's movement, that they're moving as they get to the trails. He then analyzes the video. We know from the video again that it was taken at 2:13 and 51 seconds p.m. on February 13th, and he talks about the GPS location of that phone, and it shows that it's on the Moden High Bridge. And so we're able to map Libby's location where she goes until the end of Moden High Bridge, and we show movement until 2:32 p.m. So it has to happen until after 2:32 p.m. And Richard Allen has always said that he was gone by then, I think. I think he said he was there from like 12 to 1:30 or something like that. Even if he said 1:30 to 2, he's still gone by 2:30, and they're still moving at 2:30. The phone is still moving. Libby's. The phone stops moving, doesn't move after that, registers no movement on the health app data. So where are we at that point? Can you bring up the map, please? So I want to go over the timeline that we have to this point. 12:25, Bree Wilbur arrives at the Freedom Bridge. She and the other girls are walking toward the Monon High Bridge. At 12:43, Bree Wilbur arrives at the Monon High Bridge and takes a picture, and that picture's time-stamped. They then turn around and head back towards the Freedom Bridge. At 1:26, Bree Wilbur takes a picture at the bench on the trail somewhere in that area. After that, they run into Bridge Guy. Betsy Blair passes the Hoosier Harvest Store on the way to the Mears entrance at 1:46, and she begins her walk towards the Monon High Bridge. She gets to the bridge, turns around, and heads back to the Mears entrance. We know that Kelsey's car is headed that way at 1:48, right after she drops off Libby and Abby at the Mears entrance. So Libby and Abby start their walk towards Monon High Bridge. 2 o'clock. Betsy Blair reaches the Monon High Bridge. She sees the man on the first platform. She turns around and heads back to the Mears entrance, and as she does, she passes Abby and Libby. Did she say she saw the girls? I don't remember Betsy saying she saw the girls. That might be a different group of girls that she saw. Abby and Libby proceed out onto the Monon High Bridge. We know this from the phone information and the Snapchat GPS location. And then at 2:13, the video begins, the video that Libby took with her phone, the video that shows them being kidnapped by Bridge Guy. And then at 2:32, the phone stops moving. We then know Sarah Carball traveling to the west of 300 North, and she sees a guy that's muddy and bloody like he had just slaughtered a pig, and she passes the Hoosier Harvest Store at 3:56. Actually, I think Sarah Carball going this way. I apologize. So she passed the Hoosier Harvest Store at 3:56 and then sees Bridge Guy, who is muddy and bloody. So at that point, we know that Bridge Guy, the guy on the video that Libby took, and that he's the one who kidnapped Libby and Abby, and that after that they're dead. So if we can determine who Bridge Guy is, we can determine who killed Abby and Libby. Bridge Guy is guilty of felony murder. In the act of kidnapping Abby and Libby. In the act of kidnapping, Abby and Libby died. Okay. He's guilty of felony murder. So fast forward to 2022, Kathy Shank comes across a leads form, so, like tips and things that came in prior. I moved the page and now I can't find it. Kathy Shank. Kathy Shank comes across a leads form. She's a volunteer who's assisting with organizing the numerous tips and files that were involved in this investigation. She comes across this lead sheet from Dan Doolin and it sticks out to her. It immediately strikes her as something that she's not seen before, something that has not been followed up on. So she found a lead sheet about a man who was on the trail on February 13th between 1:30 and 3:30. Okay, so he said 1:30 and 3:30. That's not true either. That's not true. That's what the state says, that he was there from 1:30 to 3:30, but he never gave that time frame. I think he gave 12:30 to maybe 2:30 or 1:30. And this tip that supposedly wasn't looked into or whatever Richard Allen was already cleared when they look at this tip sheet to claim that, oh wait, this might be our guy. He was already cleared at that point. This tip struck out. Did I read that? Okay. Yeah, the man had run into the girls on the trail, Bree Wilbur and Riley Voorhees. Kathy immediately took this tip to Tony Liggett. So she sees this tip and was like, we got to act on it. This is our guy. This tip stuck out to Tony Liggett because he knew that who the girls had run into was Bridge Guy, and if we could find Bridge Guy, we could find the killer. And all indications pointed to this being Bridge Guy. So Tony Liggett got with Steve Mullen and began to follow up on this tip. The tip identified the man who was on the trail on February 13th between 1:30 and 3:30 as Richard Allen. So they tried to verify the information. They called in Dan Doolin. They looked at his reports. He typed up a narrative from what he had found that day. He downloaded a BMV or like a DMV picture of Richard Allen. Steve Mullen went to the Hoosier Harvest Store. The information he found in the BMV that Richard Allen owned a 2016 black Ford Focus, and from your questions, we were able to determine that that is the only 2016 black Ford Focus registered in Carroll County in 2016 and 2017. So Steve Mullen goes to the Hoosier Harvest Store video and he finds a car that matched the description of the car owned by Richard Allen. Tony Liggett, the defense is going to deny that that is his car. Tony Liggett then goes to CVS where Richard Allen works. He takes pictures of that car and then compares those pictures to what they find on the Hoosier Harvest Store. And Steve Mullen testified that one clue that he was able to recognize is those wheels on the car. The fact that light is emitted through the wheels on the car, and he testified that this car matches the description of Richard Allen's 2016 black Ford Focus. The timestamp on this on Hoosier Harvest Store video 1:27 p.m. falls in line with what Richard Allen told Dan Doolin in 2017 that he got to the trails around 1:30. So October 13th of 2022, Steve Mullen and Tony Liggett call Richard Allen in for an interview. You got to see the interview, the entire interview. You got to see it for yourself. Richard Allen confirms on that day that he was wearing the same clothes that Bridge Guy was wearing on February 13th of 2017. Okay, because everybody in that county probably has an outfit similar, male wise, at least. Some females too, maybe. I don't know. He confirms that he was on the trails that day, and he actually says that I went on not only on the trails, but out onto Monon High Bridge, out to the first platform. Exactly what Betsy Blair told you. He also states that he didn't see anybody else on the trail except for the three girls that he ran into. Didn't see any other males, didn't see any other group of girls. Just those three girls. Now, in this interview, he did change his time instead of 1:30 to 3:30. He changed it from 12:30 to 1:30, and he's cooperating. He's always said it was 12:30 to 1:30. And as the interview goes on, he becomes more aggressive. Well, yeah, because you guys keep calling him a liar. I would become more assertive in my opinions as well, in what I'm saying. He becomes more aggressive. He becomes more hostile. As the investigators start to confront him with evidence, he becomes angry. He refuses to let them search his phone. He refuses to let them search his house. And then asked if Bridge Guy's him, he states, "Well, if that person's taken with the girl's phone, it's not me." Oh, I want to say really quickly, I don't I'm sorry because I have no idea what I was watching, but it was someone it was like behavioral analysis of Richard Allen's confessions or something, and he had a British accent. I have no idea who it was, so I really sincerely apologize, but this just popped into my head now. I watched this video and basically he relayed everything that Richard Allen had, like his behavior, the things that he was concerned about to this dependency uh syndrome or whatever you want to call it, this dependency thing that he has. So he's very dependent on the people in his life, like Kathy Allen. Usually this person with dependency issues or disorder, whatever it is going to gravitate towards one, maybe two people who they really trust and love. So that is Richard Allen's wife and Richard Allen's mother. And those two people are his rock, his dependency. He depends on them to go about his daily life. He depends on them to stay mentally stable and to stay grounded and to whatever. So he needs them. So the line of questioning when you're asked, another one of the symptoms of this disorder just so happens to be being really concerned about what others think. So when he says, well, it's over anyways, people, you already searched my house, everybody in my neighborhood knows that you've suspected me of this, like that is truly one of the symptoms of this disorder, is that you're really concerned about what others think about you. And um I want to point that out because you notice it in the interviews where we went over those a while ago. We went over the um Steve Mullen and the Tony Liggett interviews. One was they just came in and asked him questions or had him come in to answer questions, and then the second time they were like, come in and answer some more questions and you can pick up your car because we've already searched it now. And then they arrested him that day. So he had two interviews, and there are a lot of instances in those interviews where if you take into account that his reputation is like of the utmost importance to him, then you can see why he answers things in the way that he does. So just keep that in mind. He refuses to let them search his house and then asks if Bridge Guy's him. He states, well, if that picture's taken with the girl's phone, it's not me. Well, yeah. What else is he going to say if it's not him and he never saw those girls? What do you want him to say? I don't see the problem with that. Based on the information law enforcement had at that point, got a search warrant and searched his home. In the home, we found a 2016 black Ford Focus. You can see the light emitting through the rims. Steve Mullen said that this was important in identifying the car at the Hoosier Harvest Store video, and also find several knives and box cutters. Find a blue Carhartt jacket. Surprise, surprise. Same jacket Bridge Guy's wearing. Okay. The Bridge Guy is a lot bigger, taller, wider. So I don't think it's the same one that we see in the video. Find various cell phones. So they found a bunch of cell phones and they searched all of them. Find a Hope box with a 40 caliber Winchester bullet in it. Again, same brand and caliber found at the crime scene between the two girls in a Hope box filled with mementos, pictures, keepsakes. There's a 40 caliber Sig Sauer firearm, same caliber as the bullet found at the crime scene between the two girls. I wonder if he was registered and if they knew that he had that caliber rifle before they decided to look into him as a suspect because it fit their evidence. The Bridge Guy starter kit. Blue Carhartt jacket, 40 caliber Winchester round in that Hope box, 40 caliber Sig Sauer gun. Now, Richard Allen did have other 40 caliber ammunition in his house, but that brand was Blazer. The only Winchester Smith & Wesson Winchester round he had in the house was in the Hope chest with other mementos and other keepsakes. Again, the same brand and caliber of the round found at the crime scene. Also found pictures where he often visited the Monon High Bridge. He's familiar with the area, visited oftentimes with his family. Through the search, we found a lot of electronic devices. We searched those devices. First Sergeant Christopher Cecil told you that he searched several or extracted several of Richard Allen's devices, but one that was missing was the phone that he had in 2017. We know that because Dan Doolin took down the identification number for that phone and all the phones we searched in the house when we searched in 2022, none of them matched that phone. So they couldn't find the phone that Richard Allen had in 2017. But in some of those phones, we found a Google search from Richard Allen from April 17th of 2022. He searches Delphi, Indiana news. Really? The guy wants news in his local community, and that's problematic? Maybe there was something going on locally that he wanted to know. And also the fact that he went to the Monon High Bridge so many times doesn't mean squat because everybody in Delphi goes to the bridge. It's apparently the hot spot. Everybody was there that day when the weather was warm. It's something to do, it's a place to go, it's a place to gather, a place to meet someone. It's used quite frequently by the locals. So using that as because he was familiar with it, that means he would be the killer doesn't really jive with me. Continuing on, he says, and immediately after that, he searched, should I die now? Die now, should I die now? And again, should I die now? Maybe that's a movie. Maybe there's some context to that. Maybe he was feeling depressed that day. I don't know. He has manic depressive disorder, right? With psychosis. The gun is set to the lab to be tested. It's tested by Melissa Oberg. She's got 16 years of experience with the Indiana State Police Lab on testing firearms. She's able to conclude that the bullet found at the scene between the two girls was cycled through Richard Allen's .40 caliber Sig Sauer. that the ejector marks, the extractor marks, and the chamber face all match Richard Allen's gun, that the bullet from the scene came from Richard Allen's gun. Now, through the investigation, she examined all types of guns. She testified about that, and she was not able to conclude that the bullet found at the scene was cycled through any of those guns except Richard Allen's gun, but only after she fired it. Oh, and her results were verified 3 times by her boss, the former president of AFTA, the the association that oversees like tool marks and stuff. We've heard a lot about AFTA. One more thing, she testified in her career that she's never seen or she's never been wrong. Okay, that's something to really testify to. I've never been wrong in my 16 years of whatever. Okay, let's go back and look at all of your uh, investigations, maybe. Maybe we might want to do that. See how the pieces are starting to fall into place? See how the evidence is starting to confirm and reaffirm that Richard Allen is Bridge Guy? Not only do we have him on the trails at that time, we now have a bullet that ties him to the crime scene. So Richard Allen comes back for an interview on October 26th of 2022. He confirms, "I've never loaned my gun out to anybody. I never loaned any of my ammunition out to anybody. I never loaned my car or my clothes out to anybody." He states that he'd never been mushroom hunting out in the area where the girls were found. He has no explanation of how his bullet from his gun ended up between the bodies of Abby and Libby, 6 inches from Libby's foot. There is no explanation except that the bullet came from his gun when he racked the gun to intimidate the girls right before he killed them. That's the explanation. You have no way to prove that that's even Richard Allen's gun or a bullet, I should say. It could be anybody's, and it could have been there for months or years before the girls were found. It might not even be related to the crime. Much like he racked it in the top of the Monon High Bridge when he forced them down the hill. He was using the gun as a way to force the girls to comply with what he wanted them to do. He was using that power over the girls, and you saw as he was confronted with these things, he became angrier and angrier. And then his wife was brought in, and you saw that reaction with his wife, and you saw how he tried to manipulate her. You know, I didn't do this. I tried to convince, or trying to convince her. And at the end of that interview, he's arrested. And so at this point in the investigation, we're able to place Richard Allen at the bridge at the same time as that the girls were kidnapped, and able to confirm that he is Bridge Guy and that he ordered the girls down the hill, further able to confirm that he racked his gun and lost a bullet at the location where the girls were murdered. Now, when he's arrested, he's moved to the Department of Correction for his safety. You heard Dr. Martin testify to keep him safe. That was our goal, safe from himself and safe from other inmates. He was moved there, and eventually he was sent to Westville Correctional Facility. That could have been the case. That could have been all. Okay, my dog is like having bad nightmares or something. Shh, it's okay. You guys hear that? He's growling crazy. Okay, sorry, we will continue. He was moved there and eventually to Westville Correctional Facility, and that could have been the case, and that could have been all that we have to present you to you today, but it's not, because once he gets to Westville, he starts to confess. But before he does that, on April 2nd of 2023, he has a phone call to his mom where he confesses he's given himself to Jesus. He found the Lord, and it's important to him for him to tell his mom, not only tell his mom, make sure that his mom tells Kathy, his wife, the very next day, a phone call to Kathy. I did it. I killed Abby Williams. I killed Abby Williams and Libby German. The state plays a video, maybe it's the audio of that call. Mr. McLeland says the phone call that he made to his wife, unprovoked, unpressured, of his own free will. We don't know what happened before that call. We don't know if he was on hell at all at that time. Actually, I think he was. And we don't know his mental state before he did that. We don't have the context. So, no, I'm not going to just take your word for it. Quote, Kathy, I did it. I killed Abby. I killed Abby Williams and Libby German. After that, he continues to confess. He writes a letter to the warden. I'm ready to confess to killing Abby Williams and Libby German. I hope I get an opportunity to tell the families I'm sorry. He then meets with Dr. Walla on April 5th of 2023. Dr. Walla writes down that Richard Allen states, I killed Abby Williams and Libby German. I'm sorry, and proceeded to cry. And he cried off and on throughout that session. He reported committing the murders on his own. He stated that he made sure that they were dead because he didn't want them to suffer. He reported not knowing why he did it, but stated he knew his intentions were sexual in nature. I don't think I had sex with them, he stated, but also said if he did, he didn't remember. He mentioned not knowing the ages of the victims, but reported they were at least 18 or 19 years of age, but could have been as young as 11. He reported being selfish all his life and being a coward, and that he got scared and took their lives in order to preserve his own. He stated that he stated again, he hoped he could apologize to the families of the victims and wish that he could go back and change his actions. And we heard from Dr. Walla that on the day, no other behavior until after his attorney visits and the sudden shift in presentation was purposeful, and that he was not suffering from psychosis when he made this admission. He goes on several confessions. You're going to be able to read these. But April 7th of 2023, a door sheet. God, I'm so glad nobody gave up on me after I killed Abby and Libby. I, Richard Matthew Allen, killed Abby and Libby all by myself. Nobody helps me. I'm not crazy. I'm only acting like I'm crazy. I feel like someone maybe coerced him to write that because he did it multiple times. April 9th, I killed Abby Williams and Libby German. Funniest joke is how I killed them. I got what I deserve for what I did, and I hope I burn in hell for what I did. April 22nd, I killed those girls, so I have to kill myself. April 23rd, I killed Abby Williams and Libby German. My wife wasn't involved. I would like to confess. April 26th, I killed Abby Williams and Libby German. April 29th, she was killed, April 29th, he said that he killed the girls in Delphi with a box cutter that he stole and left in the trash at CVS, that he wants to write a confession and that he was only planning to R them, but he got scared and panicked and killed them instead. He then meets with Dr. Walla again on May 3rd of 2023, and he gives an even more detailed confession while he's being doped up on Halidol. Allen reported wanting to confess to his crime, and he wanted to tell his story. He reported seeing his parents the morning of the crime. He was supposed to go to lunch with them, but he opted out and brought himself a six-pack. He drank 3 of those beers and finished the rest later. He said, I bundled up. Once I got to the trail, I laid in wait. He reported seeing the girls and following them on the bridge. He reported doing something with his gun and stated, I think that's where the gun or where the bullet fell out. I ordered them down the hill. His intention was to R the girls and mentioned that he thought that they were older than their biological ages. Allen said he saw a van and was scared, and that scared him and caused him not to follow through with R-ing the girls, but instead forcing them to cross the creek and then cutting their necks. Isn't that worse? Like, isn't taking their lives and taking them off of this planet worse than R-ing them? Like, that doesn't make any sense. That I don't want them to suffer. I got scared. I'm not going to R them. So I'm just going to kill them instead. What? Okay. He indicated again, I wanted to make sure they were dead. He reported covering the bodies with tree branches, and he exited the area by keeping off the trail as not to be seen. He said he returned to his vehicle, which was parked at a nearby building, and he continued living his life after time passed because he hadn't been caught. We get to May 10th. You have a phone call to Kathy. I need you to know that I did this. It's okay, honey. I did it. I killed Abby Williams. Then May 17th, a phone call. You heard to his mom, I'm just worried that you guys aren't going to love me because of the fact that I said that I did it. Mom, I wouldn't sit here and tell you I did it if I didn't. another video or audio recording is played. Mr. McLeland says again, a phone call that's unprovoked. He does it of his own free will, not suffering from psychosis. The phone calls show that he also trusts Dr. Walla, his therapist, and he's meeting with her every day. After this, he continues to confess to admit that he killed Abby Williams and Libby German. Another phone call on June 5th to his wife. June 18th, you know why I'm here. I killed Abby and Libby. June 21st, and then finally on February 4th, when he's moved to Wabash Correctional Facility, he is sorry for killing the girls. Now, during those times, the time that he's making those confessions, we heard testimony from Brian Harshman that he's listening to all those calls. He's waiting or watching the videos from Westville and from Wabash and from Cass County, and he's listening to Richard Allen making those confessions to his mom and his wife. He also reads over the reports from Dr. Walla, 2 reports that I showed you earlier, 2 reports that include confessions and details of those confessions, and he said he listened to over 700 phone calls. He reviews all the reports, reviewed these phone calls, and as he's going through Dr. Walla's report, he notices something, a detail that he didn't know before, a detail that wasn't in police reports, that wasn't put out, and a detail about Richard Allen being scared after he saw a van, a detail only the killer would know. So he followed up on it. He thought Richard Allen may have seen the van on 625 and specifically the private drive where 625 turns into the private drive. As we said, that private drive leads to the home of Brad Weber. That's the only home it leads to. So he started to do some research and he looked up Brad Weber's BMV information from 200 from 200 from 2017, and he found that he owned a van from February of 2017. And so Steve Mullen and Brian Harshman, they called Brad Weber in for an interview. They want to follow up on this interview. Before that, they noticed that Brad Weber had given an interview back in February 2017 where he said that he was at work that day and on February 13th of 2017 until 20 until 2 o'clock p.m. and then he clocked out and he got home around 2:30. When they re-interviewed Brad Weber, he said the same clock he clocked out at 2:02, got home sometime around 2:30. You even had heard Brad Weber testify twice that he left work at 2:02, went straight home, got home sometime around 2:30. You also heard from Brad Weber that on that day, February 13th, 2017, he was driving his van and that the route he took to his house was down that private drive, and that when he would have been on that private drive is the exact time Richard Allen would have been there with the 2 girls. This is the van that he saw that spooked him. Something only the killer would know, and Richard Allen confessed to it with Dr. Walla. Finally, let's not forget that Brian Harshman, in listening to these over 700 phone calls, he got a feel for Richard Allen's voice. He told you that when Richard Allen, this should never been, he's not a voice analyst, it never should have come into testimony. He says, he told you that when Richard Allen was talking on the phone with his mom and his wife, his rate, his demeanor, his tone was all the same when he heard the confessions as when he was talking about mundane, everyday things. And finally, he told you as part of his investigation, he watched the video from Libby's phone and he watched it dozens of times. And he told you on the stand there was no doubt in his mind that that voice on that video is Richard Allen's, that Richard Allen is Bridge Guy. This is the one and only time that you've ever connected Richard Allen as being Bridge Guy. One and only time during this trial. And now all the pieces are clear, all the pieces are put together. So, what does the state have to prove? Count 1 is murder. The defendant, Richard Allen, killed Abby Williams while committing or attempting to commit kidnapping, which is defined as the person who knowingly or intentionally removes another person by force or threat of force from one place to another. Richard Allen is Bridge Guy. Richard Allen used his gun to force the girls down the hill. He kidnapped them and later murdered them. We call this felony murder. The murder is committed during the commission of a felony. That's what Richard Allen did. Count 2 is the same, but with Libby German, he's not only forced Abby down the hill, he forces Libby down the hill. Count 3, the defendant knowingly or intentionally killed Abby. He slit her throat. He waited to make sure they were dead, and then he left behind his calling card, a bullet from his gun. His calling card. That phrase only makes sense when you've got like serial killers who always throw a bullet, an unspent bullet in their crime scene. That would make sense. But Richard Allen is not a killer or a serial killer, either or. So he doesn't have a calling card. Count 4, murder. Again, knowingly or intentionally killed Libby February 13th, 2017, a day that started out like any other day, a day where Libby decided to go to the trail with her best friend Abby and enjoy being outside, but a day that bridge guys stole their youth and the life away from both Abby and Libby. The state has showed you that Richard Allen is bridge guy. Richard Allen went on the trail that day with his .40 caliber Sig Sauer that he arrived around 1:30, and he ran into Bree Wilbur and Rayleigh Voorhees, and that he was grumpy, creepy, and walking with a purpose, and that as he continued down the trail, he went out on the Monon High Bridge on the first platform, and that's where Betsy Blair sees him. She sees him on the Monon High Bridge on the first platform, and she testifies that he's there waiting for someone. And as she returns to the Mears entrance where she came in, she passes Abby and Libby on their way to the Monon High Bridge. Richard Allen lies in wait. He waits for Abby and Libby, and then he follows them across the bridge, and as Libby reaches the end of the bridge, she looks back and sees Abby is being followed by Richard Allen. Something in Libby German caused her to turn her phone on and record the man following Abby. Some feeling. She sensed that wasn't right. Richard Allen approaches the girls. He racks his gun and orders them down the hill. There was nobody else on the trail that day during that time that matches the description of Bridge Guy except Richard Allen. We also know from Brian Harshman that Richard Allen is the voice on the video. We know from the hard data from the phone that the video that LG or Libby took at 2:13 at the end of the Monon High Bridge, Richard Allen used his gun and his power and he forces those girls down the hill. As they go down the hill, his intention is to R them. We know that when he gets to the bottom of the hill, there is a pause. He begins to have his way with them. If you take a look at the health app data, there's a pause in the movement for 7 minutes. He has 7 minutes with them. But before he can finish his deed or his deeds, he sees a van. Brad Weber's coming home from work, his private drive. Who even testified? Back up. Who even testified to this 7 minutes that he has with this? That never even came into evidence. What's he talking about? Or he did it, he could finish his deeds. I don't know, but okay. Brad Weber is coming home from work, down his private drive to his home, and he scares Richard Allen. Then Richard Allen forces the girls across the creek to a spot in the woods, a scheduled spot, and he kills them. He cuts their neck. Libby is completely naked. Abby's naked at one time, but when she's found, she's dressed partially in Libby's clothes. Once they got him then to the woods, he used his gun again and he racks his gun and he drops a bullet and then it happens. He cuts Libby's throat first, and as she clings to life, she's grabbing for her throat, struggling to stay alive. We heard from Pat Cicero, and you saw in the picture she begins to cry, and there's a blood outlined in a tear. Then he forces his attention to Abby, and he cuts her throat, and he watches her die slowly. He then crawls out of the woods and walks back to his vehicle down 300 North like nothing happened. Sarah Carbaugh saw him, said that he was muddy and bloody like he was a slaughtered pig. And for 5 years, he lives in his community. 5 years he lives amongst us. But what he doesn't realize is that he left behind a cartridge from his gun, a cartridge that was cycled through his gun. But he also left behind Libby's cell phone. Those two key pieces of evidence led investigators to him. And then finally, if that wasn't enough to convince you, we have his confessions where he states over and over and over again, I killed Abby and Libby. And then he goes into detail how he does it, what his mindset is when he's doing, and and walks you through what he does to those girls. And in at least one of those admissions, he gives you details that only he could have, only the killer could have. And so I believe the evidence firmly convinces you that Richard Allen is guilty, or is bridge guy, and that he killed Abby and Libby. That's so nice of you to tell me how I should see the evidence. I believe this evidence firmly confirms that you should feel that he did these things. I'm going to ask you to consider all the evidence and enter a conviction of guilty against Richard Allen on all 4 counts 1 and 2 for felony murder and counts 3 and 4 for murder. Thank you. He did an hour, almost an hour, and I gave my comments throughout that, so it was less than an hour. And this guy's like, well, if I go over 2.5 hours, Judge, I don't want you to cut me off. It was an hour, less than an hour, maybe 40 minutes because I talked. The court says, all right, ladies and gentlemen, as I indicated, we will go ahead and take a little break, give you an opportunity to get up, move around a little. You may discuss the evidence, but please don't deliberate and only have those discussions if all 15 of you are present in the room. Are they all going to go into the bathroom at the same time? Is that? All rise. Jury out at 10:21 a.m. So the jury leaves. The court says, let's take 15. Jody, you can go off the record, and they do. They come back on the record. The court says, Mr. Rozzi, are you ready to proceed with your final argument? He says, yes, ma'am. The court says, all right, let's bring the jury in. All rise, says the bailiff. Then he says, thank you, you may be seated. The jury is now in the room. Court says, thank you, gentlemen. Mr. Rozzi, you may proceed. And Mr. Rozzi says, may it please the court, ladies and gentlemen of the jury, we've been here for almost a month now, and by my count, 17 days of testimony, evidence, over close to 60 witnesses, I think, by my count, 200 to 300 pieces of evidence, exhibits, videos, and you've had a chance to consume all of those things. And today, in an opportunity for the lawyers, Today is an opportunity for the lawyers, as the judge said, to try and summarize our theories of the case. The defense trusts that what you heard over the last several weeks, in terms of the words that came out of the witnesses' mouths, the form or the way that they said those words, and their consistency in their testimony, is really more important than what you're going to hear today. But it is nice to have an opportunity to try to summarize these things. And I would suggest to you that there's been 4 main themes that we've heard over the course of the last 17 days of testimony. The first one is a broken timeline. The second one is bungled ballistics. The third one is false confessions. And the fourth one is digital forensics, raw data that speaks the truth. Now, one of the other themes that has reared its head over the last 3 weeks is one that you really can't plan for on the defense side, at least before you walk into these courtrooms, because you really don't know what you're going to get from the opposing party in the case of the state of Indiana. But what we've gotten, undisputed, over 17 days is a theme about what they don't want you to hear. That may be the most important theme in this entire case is what they didn't tell you. If anybody paid attention during the pretrial hearings, you would know that he is absolutely right. He's 100% spot on. There was a lot hidden from the jury in this trial. It's what we had to tell your time. Wait, let me restart that sentence because I stopped in the middle of it. That may be the most important theme in this entire case is what they didn't tell you. It's what we had to tell you time and time and time again, witness after witness, exhibit after exhibit. We had to do their job. And let's just think about a few of those things that we get off and running, as we get off and running, sorry. First, one that comes to mind is their refusal to have that height analysis done on that 43-second video. I talked about this. I've gone over images on this about how The bridge guy video, the one that they released to the public, they clearly manipulated it and made bridge guy look smaller and wider, like less height and wider. And when we saw the unedited, untouched one from the state, the state didn't touch that one. The defense released their own exhibit. You could tell, like just by eyeballing it, you could tell that the video, the man of the bridge guy that they tried to play off is an edited version of a taller, bigger man, bigger than Richard Allen, who is what, 5'2", 5'5". He's very slight. So first one that comes to mind is their refusal to have that height analysis done on the 43-second video. We heard early in this case they found an expert. They could have spent some money and they chose not to because they were concerned about the variation in the height maybe being anywhere from 2 to 4 inches. I don't recall exactly what the testimony was. Again, I trust the 12 or 15 of you. Look at your notes and remember that. So you guys have to go back and look at that, he says. They could have had some ranges. They could have maybe ruled out some individuals, but they chose not to do that, and they also chose not to tell you. The second thing that comes to mind, hours and hours of video interviews lost during a critical time period shortly after their crimes in 2017. We brought that to your attention through the testimony of Officer Mullen. The third thing we did, this 2016 Ford Focus, somebody asked a question, an astute juror. They ran down and did a BMV search in the middle of the trial, not 6 months ago, not a year ago, not 2 years ago, 3 years ago, 4 years ago, or 5 years ago, while in trial. And then they offer you up part of the story. In order to tell the whole story, we had to offer up the rest of the exhibit, what they don't want you to know. Brad Heath's story may not be the biggest piece of evidence in this case, but I think it's good that you, the jurors, would know that a man who drives in the area of the Hoosier Harvest Store on a routine basis noticed something unusual that day. A car that had been parked just next to the CPS building from the morning until late in the afternoon, so unusual that he noted it. We told you that. Betsy Blair's story. The state put her on the witness chair. They asked her only the questions they wanted to ask to elicit only the responses they wanted to elicit, but they didn't tell you the rest of the story. We did that through cross-examination. A youthful man, I think she said boyish looking, brown, poofy hair, not short. They also didn't tell you about the vehicle she saw at the Hoosier Harvest Store when she left. That was entirely inconsistent with the 2016 Ford Focus. And then we've got Sarah Carbow. I've got to take a breath before I talk about her. Oh boy. She too did not tell the whole story until cross-examination, and what you found out is entirely inconsistent with counsel's references earlier today that she saw a muddy, bloody man on 300 North on February 13th. In fact, what we know is at first she saw a muddy man, I think 11 times in the first statement she said that he was muddy, which was shortly after the deaths of those girls. And then that she was interviewed again several weeks or maybe even a month or two later. Excuse me for not having all the dates memorized. And then she saw in her, she reported in that interview, she saw a bloody man, a man who had a tan jacket, until they showed her the photo of Bridge Guy, and then she changed her story. Or maybe it was blue, she says. She changed her story. Oh, it was tan. Oh, maybe it was blue. They conflate these words, muddy and bloody, and they're off and running. Now, there's an instruction that you're going to get, and I actually think the judge may have read it earlier, that basically says that you are the judge of the credibility of the witnesses, and I'm going to plant this in your brains for the rest of the morning. You may discount the testimony of a witness altogether. And in our business, we actually have a phrase for that. It's not one that gets used often, but it's called the concept of incredible dubiosity. Ooh, incredible dubiosity. I like that. Those are words of big words, but basically, what it means to lawyers is that when you hear testimony or you receive evidence that's so preposterous and so hard to believe that you should just discount it entirely. Sarah Carbow and her testimony we put in the incredible dubiosity box because she changed her testimony so many times, and what she testified to and what she said in police reports are different. It means nothing, but for the purposes of our discussion today and now, it's what they didn't tell you about. David McCain didn't even bother to bring David McCain in on their case in chief. We called him. David said he was on the trail sometime roughly between 2 and 3, depending on whose version or what part of the testimony you want to believe, but a very believable man. He's out taking photos that day on the trail between 2 and 3 o'clock. He said he spent no less than a half an hour on that bridge. They didn't tell you about him because it doesn't fit their narrative. Shelby Hicks, Cheyenne Holguin, two more witnesses that were out on the trail that day. Shelby Hicks, by way of her testimony, sometime probably between 2:30 and 3:30, maybe even a little later. Cheyenne Holguin, by way of her testimony, probably got there, I think she said around 2:50. Again, you can check your notes. And I left sometime around, and she left around sometime around 4 o'clock. I think there was a time-stamped photograph of 3:49 of she and Ms. Duncan on the north side of the bridge on their way back. The state didn't offer either one of those witnesses up. Rick's version of the route that he said he traveled to the trail that day. Officer Mullen got up here earlier, Investigator Mullen, excuse me, and tried to put Rick on the route that fit best for them. But in fact, we learned on cross examination that that route is not consistent with Rick's story. That Rick actually told them he didn't know actually which way he went. They didn't tell you that. The two statements, the two interrogations, one, the first interrogation on October 13th and the second one on October 26th, it wasn't until Mr. Baldwin tried to introduce those statements that you saw them. So they were hiding some of the statements where Richard Allen denies any guilt or whatever. And they don't want you to see that. It's a good theme. They don't want you to see. Don't look behind the curtain. And he's trying to expose everything well, he can't expose everything because he's legally bound because Judge Gull made orders, but he's going to get in as much as he can legally. It wasn't until Mr. Baldwin tried to introduce those statements that you saw them, and I suggest to you that when you go back and deliberate, if there's one piece or two pieces of evidence in this case that you might use to exercise your common sense and your judgment, it might be those two pieces. Sit down, watch those two statements, digest what's being said, how it's being said, the tone of what's being said, and ask yourself, how did Rick Allen handle the situation? One of the most stressful situations a human could ever be in front of, being interrogated for the murder of two girls. But you weren't going to see that until we put it in. Brad Weber's lab result from his gun. Item 101, a Sig Sauer P239 40 caliber collected from his home, could not be excluded as the gun that cycled that round. You got the exhibit. You can see it for yourself. We introduced that into evidence. The photo from Brad Weber's garage, which was introduced just a few days ago, taken shortly after the murders, where on the floor you see some sticks. Seems pretty elementary in most cases, but clearly in this case, the significance of sticks is in an odd place is noteworthy. So was he laying out runes on his garage floor? We offered that evidence, not them. Brad Weber's statement to the police. Today, again, you heard that he said he drove home that day, but What you hadn't heard until the testimony from Officer Gucci and ultimately Brad Weber himself that he actually interviewed with Agent Pohl and Gucci back in 2017 shortly after this and told them that he, in fact, did not go home that day, that he ran his ATM route. You heard that from us. That's the theme. You heard it from us. We're not the ones hiding information. Good. It's a good theme. I for his closing, I like it. The April 3rd phone calls. Today, again, the state teased up one phone call in a series of three, the middle call, April 3rd, at 5:14 a.m. We're going to get back to that in a few minutes. They tee up that phone call. What you do know from Harshman's testimony is that there was one before that. You might find it suspicious that you didn't hear those phone calls. Why not offer up some context to you? Why not tell you the whole story? It's a series of phone calls. That's where like the conversation is continued throughout the day with different people that he's talking to. The FBI parting ways in the middle of this investigation, not offered up by the state, but when Superintendent Carter got up here a week or so ago and recounts that there were issues separating. The sticks that were not recovered with blood, not recovered, the blood at the crime scene initially, and I think Officer Doolin actually testified that he went back out several days later. He had to ask them to come back out and collect those items. We offered that up, that information up, not the state. Those videos from Westville, 13 months this man sat in that isolated cell in that prison without a choice. 13 months. And all they want to talk about is what he said after he sat there for 6 or 7 months with absolutely no human interaction of any material or any substance, having been shackled every time he stepped out of his cell to go to a visit with his therapist, to take a shower, to see a doctor. All they want you to do is hear some words on a transcript or words on a recording. You must ask yourself why they wouldn't want you to see the truth. We all did that. You need context. You need the truth. And then Mrs. Oberg. These infamous photos, this magic bullet, as the defense called it, was collected and clearly was the catalyst for Rick's arrest. You saw those statements, Officer Holman. There's entire statement on October 26th was intensely focused on the results from that examination. They're trying to use that to leverage Mr. Allen to admit guilt. The importance of that unspent casing really is a big part of the state's case, if not the majority of their case, because without that, Mr. Allen's not in jail. Good point. But what happened when they brought that lab analyst in? Ms. Oberg sat in here and she talked a lot. She talked a lot. And at the end of the day, basically, what we got from them was, hey, she drew a conclusion. You should just believe her because she's worked at the lab for 17 years. And oh, by the way, why don't you just ignore the work product that she generated? Pretty much. And in fact, not only did they not offer these photographs up, they objected when we tried to. Use your common sense. And then finally, this digital phone data. Just in the last couple of days, we heard a lot of information about Cellbrite dumps and other types of extractions, but what the state didn't tell you was that at 5:45 p.m. on February 13th, there was an audio output start note on the state's own timeline that demonstrated that someone plugged that phone into an accessory. And in fact, if you look at that Cecil report, I think it is, or the Cellbrite report that you have in evidence, you'll see it actually notes on there that it is headphones. And then he says something inaudible. What a time for an inaudible, Ms. Clerk Court Clerk. I mean, what a bad time for an inaudible when we're in the middle of a closing here. They didn't tell you that. 1032 audio output in same situation. They didn't tell you about that either. And then finally, the 4:33 a.m. In fairness, maybe there was some discussion about that, but the explanation for that not offered up by the state. You should question the credibility of this investigation because of the things they're not telling you. There's also the chapter of desperation that unfolded over the last 3 weeks. First example is the magic bullet. They got that round. They interrogated Mr. Allen and immediately arrested him right after the interrogation on the 26th, and this thing moved forward. There was also that van, the one unique fact that they had mined out of months and months of therapy notes, hundreds of hours of video, hundreds of minutes of phone calls, maybe thousands. That one unique fact. And what do we find? That just recently they were running searches, talking to Brad Weber, trying to figure out a way to retrofit that fact into the narrative. When Mr. Weber testified, you may have remembered he was contacted by Officer or Investigator Mullen, who basically said it was a cold call to him. They wanted to bring him in to talk. But it was interesting that Mr. Weber himself indicated that he generated some text messages to prove his case before he got to the police station. Didn't see those text messages, not part of the evidence. In the middle of that desperation to try to fit that van into this puzzle, you didn't hear about that 2017 interview with Gucci and Agent Pohl, where he said that he was somewhere else that day. And in fact, Mr. Weber actually testified that he normally drives his Subaru to work and he does not often go home after work. So he wouldn't have been driving the van that supposedly spooked Richard Allen, and then he decided to change course. Instead of R-ing them, he just killed them instead, which is better in that situation. I don't know. Stupid. The vehicle search, again, uh, sorry, those all are facts that were elicited by the defense. The vehicle search, again, more desperation. The vehicle search of the 2016 Ford Focus, which happened while this trial was unfolding, not, years ago when the investigation was taking place. 7 years to figure that out. Happened just a week or two ago. DNA, we saw that. They tested some DNA a week or two before the trial started. Hair strains of Abby Williams' hand in Abby. Let me read that again. They tested some DNA a week or two before the trial started. Hair strands in Abby's hand at the crime scene, items that were collected 7 years ago. Still trying to figure it out. They still haven't. They're still investigating, which means Richard Allen, the case isn't closed. So Richard Allen should not be locked up for this. So they tested some DNA, blah, blah, blah. Desperate. The admission of internet searches. There were some searches offered up by the state. Mr. McLeland mentioned them earlier. October of 2022, searches, he said, counsel says by Mr. Allen. There is no proof, in fact, that Mr. Allen did any of those searches. The state put in an affidavit that said it came from an email account registered to Mr. Allen. They're molding those facts into a favorable scenario, but that is just not consistent with the evidence that you have. But be that as it may, someone in Delphi is searching on that internet about Delphi murders. If that's the case, we're going to convict half of the citizens of Carroll County. Searches for the killing of the sacred deer, a movie. If that's the case, we're going to convict half the people in Carroll County. So he was looking for a movie. They're desperate. And then the other day, during one of the breaks, the state having realized that the 545 and the 1032 transactions on that phone existed, ran Officer Cecil downstairs, did a quick Google search, came up here and tried to offer you up some fast food, a Google search, the same kind of search that he said he doesn't normally rely upon when he conducts investigations. So he's kind of contradicting himself there. Desperate, absolute desperation. And then maybe the one that sticks out the most, Dr. Kaur. It's really hard to forget Dr. Kaur's testimony in this case because of this one absurdity. He testified when I deposed him earlier this year, I think it was March, he acknowledged that at that scene that there had been more than one murder weapon, straight edges and serrated edges. He said, I forgot about that, so I'm glad he brought that up. He said nothing about anything in particular, and then we find that between the time I took his deposition and the time that he testified, he walked into his garage and all of a sudden, ta-da, it might be a box cutter. All of a sudden, he just realized it was something other than what he had been talking about. He's been talking about straight edges, serrated edges, and now he's like, oh, it's a box cutter. Of all the things on the planet that just popped into his mind. But what did you find out? 3 meetings with the prosecutor since I deposed him in March. This man has testified over 200 times. I think he said 7,000 autopsies. He's been in courtrooms all over the place. I think he said even Montana recently, or he testified in a case in Montana. No supplemental report, nothing. No reference to, hey, I might have changed my mind about a material fact. This is desperation at its finest. So basically, he's explaining to the jury how the prosecution is sandbagging the defense the whole time, and they have to keep correcting course throughout the trial. Surprised that this is going the way I'm surprised Gull is letting it all happen. I'm surprised Nick didn't whine and be like, "Excuse me, Judge Gull, he's saying bad things about me." And then she'd be like, "Okay, sustained. Don't talk about Mr. McLeland in any negative way." Like I'm surprised that didn't happen so far. But we're not done yet. Okay, so desperation at its fine line, timeline. Let's talk broken timelines. Now, there's really 3 times here that the state has offered up that matter. The 213 video is one of their bookends, if you will. The 355, I'm sorry, the 357 time, which is consistent with what they say when Sarah Carbaugh says that or saw the image of whatever she saw on 300 North. And let me suggest this, it would not be entirely unreasonable to go back in that room and think to yourself, I don't know if she saw anything. It's not out of the realm of possibility. 213, 357. Those are kind of the bookends. So 213 is the video that Libby takes at the end of the bridge where the guy says down the hill. And the bookend, the end time is when it stops moving. I think it stopped moving before then. I can't remember what 373. Oh, 357. That's right. 357 is when Sarah Carbaugh saw the muddy, bloody guy. So those are the bookends, he says. That's the timeline that we're looking at for the killer to make his moves. And then in the middle of that, you have this 232 time, which is when the state suggests that this phone was silent and no longer functioning. By their theory, that phone was where it was recovered on the 14th around noon under Abby's body laying on the ground. Now, their timeline is dependent upon 2 people. Not to belabor the point, one of those being Betsy Blair, who saw a youthful man who looked boyish, 20s or 30s, brown poofy hair. He didn't seem short. None of these things are consistent with a 5'5" Rick Allen. Why? It may be because she saw somebody else, right? All these descriptions of people, and they describe bridge guy, but they don't describe Richard Allen. Sarah Carbow, not going to waste any more time on her. Her description was worthless at best. At worst, created by offering her up a photo of Bridge Guy and then asking her what she saw. In our business, from time to time, we didn't have it in this case, but we will see photo lineups where it's kind of like in the movies and the police will be looking for the suspect. Maybe there's an eyewitness. They'll put, typically 6 or 8 individuals on a lineup and they'll ask, the witness to look at and identify somebody. And the reason why is because if you put one face on there or 2, then you ask, you're just more likely to get the answer, to get the right answer, the answer you want. It's called suggestivity. She's suggestible. You can kind of manipulate her to think that that's her own thoughts. In this case, that's what's happened with Sarah Carbow at the very least. Why is David McInlet at the very least? Otherwise, she's corrupt, or maybe was doing it for favors from the cops or something. Maybe she's an informant. Maybe she's got criminal record. I don't know. But why? At the very least, it was her being suggestible. At the worst, it was her being complicit. Why is David McCain, Shelby Hicks, or why are David McCain, Shelby Hicks, Cheyenne Holguin all important to this timeline? Mr. McCain arrived between 2 and 3. He said he was out on the trail an hour or more, if I recall correctly, at least 30 minutes on that bridge taking photos. And we know from the evidence that he was there before Shelby Hicks arrived. So you've got kind of 3 stages of individuals arriving on that bridge on that day it's a bigger time period, between the 2 and 4 o'clock hour. If you want to take it bigger, David McCann, Shelby Hicks, Daniel Pearson, Cheyenne Holguin, and Shelby Duncan. And what we know is McCain was there first. He stood at the bridge on the day where I think Pat Brown and Jay Johns identified as having been a very nice day. One of them mentioned that they could hear people on the bridge when down near where the girls were. This was on the 14th, but it gives you some idea of how well sound travels in that area. As the crow flies, not that far from the bridge. As the crow flies, not far from the bridge, the top of the bridge of where the girls were at rest. McCain stood on that bridge, heard nothing, he saw nothing. Shelby Hicks said she thought she arrived around 2:30. She remembered at some point taking a phone call from her dad. My recollection is that phone call came sometime around or after 3 o'clock, shortly after 3 o'clock. She said she was almost there when the phone call came in. Down the Mears connector to the right, the phone call came in and then went back towards the high bridge with Mr. Pearson, past Mr. McCain. So, in time and sequence, she and Mr. Pearson were second. They sat on the bridge. They saw nothing. They heard nothing. Cheyenne Holguin shows up with Shelby Duncan around 3 o'clock, maybe 2:50. Go straight to the bridge. They walk all the way across the bridge to the south. They got timestamps on their phones. They used the restroom on the south side of the bridge, walked back across the bridge to where Hicks and Pearson formerly were. 3:49, I think, was the timestamp on that picture when they were sitting on one of the platforms, I think smoking a cigarette. They heard nothing, they saw nothing. Dr. Kaur said that from a medical standpoint, it's possible that each of the girls, and I'm estimating, so look at your notes, could have lived anywhere from 5 to 20 minutes with those injuries, vocal cord not severed, able to talk, able to scream, and able to make a noise. Despite all that, no one saw anything, no one heard anything, not a peep. The possibility of multiple actors in this case. The state has completely ignored this possibility. They don't even talk about, or they don't even want to talk about it. They don't want to talk about it at all. It doesn't fit their narrative. Lots of cars and people on the trail that day heard testimony about that. The distinct possibility that somebody could have accessed the bridge from the south side, the Weber side. Teresa Liebert came in here and said she noted something unusual that day near her dead end road. A strange man that was not familiar to her, she couldn't explain. It was plausible that there could have been activity on the south side of the bridge. Sheriff Lesenby's statement that law enforcement had communicated with each other that at one time they believed there were more people involved, that's from the sheriff in 2017. Dr. Kaur's timeline, or Dr. Kaur's testimony regarding potential for multiple weapons. All those things lend to the possibility of multiple actors. But what's the reality of this? Again, the common sense side of this. On February 13th, if you accept their theory as entirely accurate, you would know that those girls were ushered down the hill, through the woods, across the creek, undressed, wounds inflicted on one of those girls, while the perpetrator or perpetrators, in their case, one person, they believe it's him, was controlling the other girl. Wounds inflicted on the girl, Abby, then redressed, sticks retrieved and placed in an unusual formation on the bodies, and then the perpetrator flees. A very labor intensive crime scene, 213 to 232 by their standards. That suggests a possibility of multiple actors, even if you believe their story. They say that it was done by 550 or by a 5'5" man, done without a detectable sound, without a single trace of DNA evidence that at the crime scene. The prosecutor asked you in voir dire up in Fort Wayne to exercise your common sense. Now is the time, and common sense will dictate that it's just implausible that you could have that could have happened in that short amount of time. What do we know about Mr. Allen's actions in February of 2017? Within a day or two after these girls were found, Mr. Allen called himself out to law enforcement, picks up the phone, he calls the police, says, "Hey, I was out on the trail that day. I'd be happy to help. Where would you like to meet me?" They end up at the Save-A-Lot, talks to Officer Doolin, hands him his cell phone. Officer Doolin records that information, and Officer Doolin said during that interview the experienced law enforcement officer that he still is, said there was nothing unusual about the meeting with Mr. Allen. Even in 2022, he was cooperative with the police. Took him into the station. Sheriff Liggett and I, Investigator Mullen, I might be mistaken about that, interrogated him. He stood there and he told them that he didn't do it. He couldn't. And he cooperated. Then, on October 26, 2022, knowing at this point that he's a suspect, what does he do? He goes back to the station, cooperates again, and in the face of lies call it the Reed technique, call it whatever you want, what we all know is it's a lie. In the face of those lies about the bullet coming from that gun and about his voice being determined to be the one on that video and about witnesses IDing him at the trail, he asserts his innocence. And the state wants you to believe that because the tone of his voice changed by one note, that somehow that's evidence of his guilt. Insulting. I suggest to you that if somebody was bearing down on you for the murder of two girls, your response might be the same. Then his wife was leveraged to try to get him to come clean. He stood his ground. He said, "I didn't do this. I don't know how this happened. I cannot explain something that I don't know." What other explanation is there? And finally, for 5 years after the girls were found, Richard Allen lived in his community. He worked right down the street at the CVS, a place where the public comes to every day. He had a chance to get out of there. He had a chance to lay low, but there was no reason for him to do that because he wasn't responsible for these crimes. That magic bullet, let's talk about the magic bullet, item 016, a case of bungled ballistics. Questions about that cartridge from the get go, collected underneath some leaves on the ground in the woods, properly photographed, or I'm sorry, poorly photographed, poorly photographed. There were, I was like, wait a minute, no, it wasn't properly. Poorly photographed, and they didn't take pictures of it when it was in the ground. They didn't take pictures of it being collected. I think once it was removed from the ground, then they took pictures of it. So, and they weren't the greatest of pictures. That cartridge ends up at the lab, and Ms. Oberg examines the cartridge and eventually receives the firearm from Richard Allen's house. Now, this is important, and this is kind of a second layer, but you did hear this. You did hear about some of the bias, confirmation bias, things of that nature with these exams. It's always good in these examinations to be kind of blind about what you're doing. But in this case, because you had this cartridge way ahead of time, there was some discussion about, hey, this is the kind of firearm it might have been cycled from. We have some ideas. I think some of the testimony was it was a Sig or a Smith and Wesson. And so Mr. Allen's Sig Sauer was brought to her. They had already kind of narrowed this down possibly to two different firearms. But what we know is that when Ms. Oberg took some stock rounds out of the cabinet, out of their vault, she placed it in this firearm 4 to 6 times. I don't recall exactly. She cycled these rounds, and what we know is the marks on those tested cycled rounds were not sufficient to compare with the bullet or with the magic bullet. So what do we get? Apples to oranges. She shoved some test fires in that gun, starts firing away, totally different environment. Dr. Warren talked to you about that. Higher intensity changes the nature of that environment. But she does that, not necessarily improperly, but she does that, and she starts off on her examination comparing apples to oranges again. Dr. Warren said that there can still be, but here's the problem: it requires a lot of work, a lot more intensity, a lot more corroboration, a lot more research, and you need to explain your work. You need to offer it up. It needs to be vettable. Subclass versus these individual characteristics. I'm not going to bore you with that, but for the rest of the afternoon. But what we know is that that is where the battle lines are drawn in this industry. You've got to be able to distinguish between individual characteristics and subclass characteristics, or it's not helpful at all. And in this case, with regard to those tools, the ejector, the extractor, the barrel hood, she documented her subclass findings only with the ejector. She documented nothing with the extractor and nothing with the barrel hood. And as it turns out, in terms of peer research, error studies, there really isn't any that even exist when you're comparing apples to oranges, cycled unfired rounds versus fired rounds. And then came the photograph discussion of all the things that we've heard in this case that should upset you and that should cause you consternation and concern about the task that's been placed on you. There are these photographs. They have the hairline down the middle. You can look at the two sides. If you're as old as I am, you may remember ant races on TV. To me, I think a reasonable person would look at these and say, this is like ant races. I don't even know. But if you believe that these are helpful to you, take a look at these and stare at them and ask yourself, where in the hell are the sufficient agreements? Where are the ridges that match? So you're just supposed to trust her word versus what your eyeball can see in the microscopic comparison photographs. In fact, there's way more that doesn't match than what matches on every one of those photographs, save one. I'll show you that photograph in a minute. And again, item LL, to the extent that you believe there's a match there, you're entitled to your opinion, as my colleague once said. Use your eyes and your ears. Use your eyes. See for yourself. Item NN. I don't know how you could make any sense out of item NN, but that's a photo that she took that apparently has no meaning to her evaluation. And then item MM, we've got some areas here where there's some similar lighting, but a lot of areas that are different. I don't understand what's going on with that. She took the photo and then items OO, maybe the most notable photograph in this case. You may recall Ms. Oberg herself acknowledging, and if you look at this photograph, I think the first thing that jumps out at you is that there are some similarities there. There are some ridge lines, there are some illuminated that are kind of close, but what you would also recall from the testimony is that both Miss Oberg and Mr. Warren, Dr. Warren, have identified that this is classic subclass characteristics. Ms. Oberg said at one point, well, there's some other marks that I'm looking at. But these matching marks, if you will, to the extent you believe they're matching are classic subclass characteristics. This photograph is actually a really good example of why This is a dangerous business. The science is, if you will, I'll concede that you can call it an applied science, although there are distinguished bodies in this country that don't agree with that. But the science, if you will, is under fire. There was a laboratory in Rhode Island that was shut down because they weren't distinguishing between subclass and individual characteristics just recently, about a month ago, or in fact. This is the congenitive game, or I'm sorry, this isn't congenitive. This is a subjective game. Ms. Oberg sat here and told you, I get to see a motion picture. I get to take the pictures that I want to take, but you should ignore those in this case because they're not important or they're not reliable or they're not valuable or whatever word you want to use. You should just believe me. That's what she told you. And if that's enough for you in this matter of the highest consequence, then there's nothing I can do about that. The question that becomes, why didn't the defense have this bullet examined? An explanation might be that after consulting with with Dr. Warren, there was no point in doing that because the work was so poor. It's also not our burden to offer not our burden of proof to offer up his innocence. It's their job. It's their job. It's their burden of proof. Why didn't they get that bullet re examined after it was in dispute? 7 years they've had it. And then we've got those confessions, false confessions, life in solitary confinement. Rick Allen's situation in the case is unprecedented. The warden himself acknowledged that in 25 years that he worked at the DOC, he was not familiar with a circumstance like this, at least in the last 3 to 5 years. I think he said 5, maybe 3 to 5, that he was working in Westville. He had never had a pretrial detainee without a criminal history in the WCU. Apparently unprecedented. Dr. Walla herself acknowledged the same, that Mr. Allen's circumstances were unlike any she had ever seen. And I think Dr. Martin even told us the same thing. A man who had been in the prison system in Florida for years, he remembered that he distinguished between pretrial detainees being held in jail versus those being held in prison, whether they were in a circumstance like Mr. Allen's. Mr. Allen was a fragile egg when he landed at his doorstep. That's what Dr. Martin, I believe it's Dr. Martin, is quoted as saying. There was a little bit of back and forth about whether or not he had a serious mental illness. That was cleared yesterday by Dr. Martin. It's a DOC designation. It's a business designation, major depressive disorder. I would suggest that that really is a serious mental illness. Dr. Walla herself admitted it, but it is a business designation. Dr. Westcott said that he had, I think she defined it as critical mental illness, or there was some other phrase. I'm sorry, it eluded me. But have, what he did, but that he did have a serious mental illness. Okay, sorry. He was tossed in the most secure unit in the state of Indiana and he was treated just like the rest. That's what we heard. He was treated just like the rest. The rest of the convicted murderers that were his cellmates, the rest of his convicted I won't say that word, that were predators that were on that unit. The most heinous individuals in the state were his neighbors, and he was treated just like them. In fact, not only was he treated just like them, he was immediately placed on this self-unaliving watch. Usually it's like 2 weeks, 30 days. Anyone who comes into a new prison, especially new people, but even people, prisoners being dragged out of other prisoners, they're given a one of these rooms, you know, uh, on the screen. I'm highlighting the words, self-unaliving rooms. So they don't harm themselves because it's very common that when someone new comes into a prison, especially for the first time, that they might try to take their own life when they're there. So they are watched very closely for. So like that part's not even in dispute. Like they don't care that Richard Allen was being watched. It was the way in which he was being watched and video recorded everywhere he went, when that's not how other inmates are even treated. So I don't know. It's just interesting. The evidence supports that no human, no matter how strong, could endure these conditions for that long a period of time without having some kind of breakdown. Stripped of almost every necessity of a man's life and sent to a place where you have very few, given a self-unaliving smock, basically a caveman gown. You have to eat off the floor, compete with mice droppings and ants, all the while his neighbors calling him a child killer, a baby killer. In an 8 by 12 cell, cinder block walls, concrete floor, no blanket at times, steel toilet that was next to his where he laid his head at night. And if that wasn't enough, when he got out of that cell 3 to 5 times a week to go to rec, he got to go to a similar unit, a similar cell. They call it outdoor rec. It's a cage with a screen on top. I recall asking Warden Gallipo at one point about Rick's opportunities to go to rec. There are rec yards all over the facility, ball diamonds, volleyball courts, baseball courts. He didn't see one, not one time. The whole time he was there, he didn't get any exercise. On top of that, when he got to go to therapy, shackled his arms, put a box cuff on him, his legs, belly chain, a lead. I called it a leash. Argue about that all you want. And he was walked to a cage down the hall where he got to talk to his therapist. That's like, I don't even do that much to take my dogs for a walk. They slip on a harness and go. Like all these other things that, they had to get him on, the shackles, the box cuff, whatever, the things on his legs and his hands, a leash, basically. So same with the shower, the 30-day rule in the DOC, the 30-day rule. Here's the point. Solitary confinement is damaging to a man or a woman's brain. It doesn't matter if you have a business designation as a safekeeper. Duh. If you're held in solitary confinement, Dr. Gracian said the international standard was 15 days. The prison's policy is no more than 30. But it should be 15 days, no more than 15 days, because that is when you can start doing some psychological damage. But when you're held in solitary confinement, the evidence is firm that eventually you're going to break. You can only handle so much. Rick Allen, more than 30 days, those 30 turned to 60, 60 turned to 90, 90 turned to 120. And I could keep going, keep doing the math. When the dust settled, he was there for 13 months. How much can one human endure? How much? And they didn't want to show you the video. They didn't want you to see that. It's insulting. The state's response to this, Trooper Harshman, certainly a good cop, says he was right where he belonged. They could see that he may have been psychotic. Well, Dr. Walla, I wouldn't put any credence in what she said. Her testimony is he was psychotic from March, April, May, and June. They're willing to concede that he may have been psychotic. The state is, but they want you to cherry pick somewhere in the middle. He's psychotic on May 13th, but not on the 14th. So let's take that statement and let's throw that up there on the screen and hit play. So well said, yes. Um, he was getting stuck with needles during that whole time, all the way until mid-June, antipsychotics, which means, by extension, that you're psychotic. They wanted to say that he was faking it, but they didn't want to show you his body language when he was saying these things. If he's faking it, then why are you giving him the medication to counter it? But as it turns out, Dr. Waller herself said, even after some forethought, hindsight, that even she wasn't sure if her note regarding the feigning behavior was accurate. She said, I don't know. Dr. Martin, yesterday, after watching that video on the day that Dr. Martin claimed he was oriented to time and place, then changed his mind right there on the stand. Who wouldn't? Who would possibly watch that video and for 1 second believe that the man who was oriented to time and place? What did we find out about the standard at the DOC when it came to the care of this man? It was to keep him alive. That was it. That was the medical standard within which these people were working to keep him alive. You should be insulted. Dr. Gracian talked about a more technical level about delirium and false beliefs and false memories. A man who's seen this time and time again over his 30 or 40 or 50 years. I've forgotten that. I think he said he started practicing in the 70s. False beliefs, false memories start out as false beliefs is what the testimony was. They're not based on actual factual circumstances, they're based on beliefs. I suggest to you to go back and look at that April 3rd, 5:14 phone call, the only one that they want to show you. Go to page 4, and at the top, Rick starts off the phone call. I did it. You did what? No, I did it. I killed Abby and Libby. And then by the time you get to the bottom of the page, a few lines down, you start to see these signs of these false beliefs. No, I mean evidentially, or evidentially did, or evidentially did it because maybe I did. I think I did. Then Rick starts to communicate how he thought maybe he called his father earlier, he couldn't remember. And then he says, page 5, line 22, I think I did. Line 24, because I think I did. Page 6, line 1, I wish I could say I didn't. I don't know. I just wish they'd kill me and let me apologize. These are false beliefs. Dr. Gracian said, classic case. And then there's the iPhone, Libby's cell phone, Apple 6S, I think is what it was. Does that thing ever have stories to tell? Yes, it does. The story has relied on that heavily and want you to believe that the information they offered up about the phone is accurate. There were 3 timestamps on that phone that I already mentioned to you, 5:45, 10:32, and 4:33 a.m. And how do you interpret this information? And I suggest you think about this first. The phone has no personality, it has no feelings, it has no emotions, no opinion. It just generates raw data. It speaks for itself. One of the most common tools in law enforcement these days is in solving crimes, actually, because it's like a little mini surveillance of everything you do. There's one simple conclusion to be drawn by this 5:45, this 10:32 time frame, and that is that when someone was using that phone, someone plugged something in. Someone plugged something into that phone. The phone went dead after 4:33 a.m. You heard testimony that there wasn't any activity after that. That makes sense. There wouldn't be any Apple Health activity because it was dead. The phone died. But we do have Apple Health data from earlier. Mr. McLeland mentioned in his opening or his closing, there's a reference on there to a 20-foot change in elevation. You've got a map on the south side of that bridge. You should revisit that map. David McCain said, and I'm approximating that the distance between the top of that bridge and the water was about 65 feet, I think is what he said. He knew that place well. He was part of the effort to establish that bridge and that trail. Exercise some common sense. Go to the south side of that map or the bridge on that map. Look at that Weber Road, and you're going to see it's about halfway down to the river bottom, that private drive. About half of that 60 feet and 30 feet. Maybe we can approximate. I don't know when 20 goes to 30 on the Apple Health phone. I don't know if it's at 29:05 that it switches to 30. I don't know, but what I can tell you is that the location of that road relative to that 20 feet is curious at best. Not ironically, that private road leads to Brad Weber's home. Not ironically, he had sticks in his garage. And not ironically, he had a Sig Sauer P239 that couldn't be excluded as one of the firearms that cycled around in this case. It's the state's burden of proof. It rests squarely on them, not us. And the state had 7 years to figure out 545 and 1032. There's no explanation because the phone is right. It's right. You need facts. The state wants you to believe there's this box cutter. We talked about that earlier. Dr. Court's testimony is hard to swallow. The timing, even his tone and the way he testified. You can draw your own conclusion about that, but it seems like a retrofitting of that particular fact. By the way, it's also a box cutter. It's one of the most common tools on the planet. They searched Richard Allen's house. They wanted you to see those knives earlier when they put them up on the screen. They wanted you to see those box cutters. But there's not one piece of trash evidence on any of that that connects him with, oh, I'm sorry, trace evidence. I said trash. Yeah, that's very different. There's not one piece of trace evidence on any of those things that connect him to the murder of the girls at the crime scene. They have no proof that he discarded anything. That's just a statement with no validity. The van comment. And again, we know there's discrepancy in Mr. Weber's statements. It's a van, too. It's a van. Again, one of the most common vehicles we see on the roadway. God only knows what a BMW search might have shown as to how many vans were in Carroll County in 2017. And then uh, Dr. Westcott had a really unique, not unique, she had a really interesting observation when she testified the other day, and it was this. She noted that the medical notes that was her version or her summary of what Rick Allen told her during some of these therapy sessions in the cage flowed like a story. But for 4 months, this man was in a psychotic state, disorganized speech, fragmented thoughts. No man in that state would talk like that, would be able to provide details like that, but yet those things showed up on paper. Dr. Wallace's circumstances in this case and her involvement in this case are clearly an issue and you need to tackle. That you need to tackle. The jury needs to decide. Is she a credible witness or not? The word bizarre comes to mind. The psychologist, I should say, who was infatuated with this particular case, who was assigned to him, and didn't disclose her personal interest in this case until after she was assigned to him. She visited the Monon High Bridge. She lives in North Chicago. She works in northern Indiana. It is fair to question the accuracy and authenticity of her work. The unique fact that he lied in wait before those girls were ushered down the hill. Well, look at the video. Does that look like somebody who's lying in wait? In fact, they put forth testimony that he was standing on one of the platforms on the bridge earlier and there was somebody staring at him, Betsy Blair, and that he walked down the trail, if you believe the statements from the state. Voorhees and Wilbur saw him. That's not lying in wait. Then they want to retrofit this idea that, oh, in that video, now you can hear the gun cycle. Well, you can play the video again. There's a lot of crunching and munching and a lot of other things that you hear the videos outside. But to fit their theory, they're interpreting one of those sounds as being a gun being cycled. And there's just really no proof of that. None. I should have stuck. Why would it Why would he cycle a bullet there and also at the crime scene? Makes no sense. I should have stuck out, or I should have stuck that in the desperation column. And then they wanted you to believe for a few days that Richard Allen was an alcoholic because one of the statements from May suggested that he drank some beers, and somehow being an alcoholic is consistent with somebody who drinks a few beers and goes out to the trail. Look at your medical records. I think there was some testimony yesterday from Dr. Martin that Richard Allen disclosed to him that he drank occasionally, no references to him being an alcoholic. Desperation. The search for the girls has been called into question. From what we know from Mr. Sterrett is on February the 13th that there were search crews sent out. Some of them were service personnel, firefighters and such. Others were just lay people trying to help, and we know that that search, when it went in somewhere between 9, 10 o'clock, and 2 in the morning. Both sides of the river, I should say the creek, both sides of the bridge. Mr. McLeland's argument is they weren't looking for dead girls, so they wouldn't have found them. There were no leaves on trees in February of 2013. The visibility was great. I think Jake Johns, or the other gentleman that was out there, Pat Brown, said that you could see a couple hundred yards even at one point. You can check your notes on that. But basically from close to that cemetery all the way down to where those girls were found. These people had lights. They were on foot. Mr. Sterrett said they were moving hastily, trying to cover a lot of ground. There was a lot of questions about whether or not the girls were there on the evening of February 13th. The state's theory, back to this lying in wait, is that he was walking with a purpose that day, suggesting that Mr. Allen had a plan, that he must have known these girls were on that trail. uh, Walking with a purpose, but yet there's not one single item of digital evidence. Digital evidence, social media, or any connection whatsoever, whether it be familial connection, a work connection between this man and those girls. Nothing. His clothing. Counsel says he's wearing the exact same clothing they collected, a Carhartt jacket. Boy, there's a revelation for you. A blue Carhartt jacket in a closet in Carroll County, Indiana. The Hope Box. He's got a Hope Box, and there's a round in there, and it's a Smith & Wesson 40 caliber. Mr. Doolin testified that Smith & Wesson rounds, very common, one of the most common manufacturers in the industry. You can go back and check your notes, but Oberg had that round. That was closest round number 1, and you can check your notes, but my recollection is that she couldn't generate any comparisons between the cyclings on that round and the cyclings on this one. She could not generate any comparisons when she did the cyclings. Counsel said earlier that Richard Allen found the Lord, and that's why he came clean. He found the Lord. In that 8 by 12 cell with no bed sheets, with nothing other than a Bible for months, what does a man find? Can you blame him for taking out that Bible? Can you blame him for trying to find a way out of these circumstances? He's not the only guy who's found God in comparison, you can rest assured. And then the voice on that video, the state says Trooper Harshman identified Rick Allen as the voice on that video, but you heard Investigator Mullen the other day on the stand over the course of the 5 years of this investigation, phone call after phone call after phone call, tip after tip after tip, people who were called in and saying, I know whose voice that is. It's Bob Smith. It's Jerry Smith. It's John Doe. Dozens and dozens. I think he even said maybe hundreds that they know of. And all of a sudden, somehow, Trooper Harshman, mind reader, is able to identify Richard Allen's voice as the one on that video. He's not a voice comparison expert. Exercise your common sense. Speaking of common sense, there is the 10,000-foot view of this case, and that's simply this in 5 parts. No one identified Richard Allen as the man on that bridge. Not Mrs. Voorhees, not Miss Wilbur, not Miss Blair, and sure as hell not Miss Carbow. And in fact, if you believe what they said, they were actually identifying people that were not Richard Allen. Number 2, no one piece of digital data from any phone, any tower, or any form of social media connects Richard Allen to that crime scene or those girls. Number 3, not one fingerprint, shoe print, or other piece of clothing connects Richard Allen to that crime scene or those girls. Not one scrap of DNA on either of those girls or any of the surfaces around the scene connects Richard Allen to those girls or that scene, a very labor-intensive scene. Not one speck of trace material was found in Richard Allen's car or his house that connects him to those girls. If you want to believe Sarah Carbow, Ms. Muddy and Bloody, he slaughtered a pig, you bet your bottom dollar when he got into that car, he would have left some trace evidence. That car was collected by the police and secured, examined. Even if it's 5 years later, in the world we're living in, they'd have found it. It's unprecedented in the modern era of law enforcement investigation that they would have no forensic evidence connecting Mr. Allen to that scene. Now, as the judge said, the rules permit me to speak only once on Mr. Allen's behalf. It's been a long haul to get to this point, not nearly as long as the journey that the Williams family has had, or the Germans families, the Patty family, not nearly as long as the journey that the Allen family has had to get to this point, and certainly not nearly as long as the journey Mr. Allen has endured as he processed through the doldrums of the DOC. At the end of the day, the state's timeline has crumbled. The magic bullet is nothing more than a tragic bullet. It was the catalyst that landed Rick in the DOC, a terrible place. At the end of the day, they want you to ignore this. 5:45, 10:32, and how all of a sudden at 4:33 a.m., by their theory, after that phone had laid under the young girl's body for hours and hours and hours, all of a sudden it receives service. It doesn't make any sense. That phone has no personality. It's not manufacturing facts, it's raw data. All those things make it virtually impossible that Rick Allen was responsible for these offenses. But let's just say for a second that you want to buy into the idea that they've got the smoking gun, because Richard Allen confessing these crimes, if even for a second you've inclined to consider those claims, consider this. This here is called a rack. It was a tool that was used in medieval times to punish people, even up until the 13, 14, 1500s. Here's a picture of what it might look like back in the very early days. There's also a tool called thumb screws. Thank you, Max. Another medieval device. That is what was used to interrogate people. This is what it might have looked like back in the day, an illustration. But as a society, we've evolved. It happens. This ultimately gave away to other forms of interrogations, more subtle ones. One of those forms was throwing somebody in a cell and throwing away the key. It's called solitary confinement, a much slower and more painful form of punishment and interrogation. Whether intentional, reckless, or negligent on the part of the Department of Corrections, somebody should have spoken up. A team or 4 or 5 doctors, police officers watching these videos every day, the warden visiting the cell. When was somebody going to say, something's wrong here? This isn't right. Where is the moral compass? You're the moral compass. You may have thought we moved away from such harsh practices. Every now and then, our system of justice, we're confronted with circumstances that remind us and direct us in another direction, another course of action, another way to handle things. That time is now. That's the power of the state, and it might be a crude example, but it makes a point. Now's not the time to step back to the Middle Ages in terms of crime and punishment. Now's the time to step into the ring, to have a voice and acknowledge that this isn't the way we punish people. No man or woman should be treated like this, whether guilty or innocent, and rendering a verdict of guilt in this case would be endorsing this behavior, this process. You should not do that. We're asking you to set Rick Allen free, and we're asking you to find him not guilty of these crimes. Thank you. I'm going to ask you guys, whose closing do you think was stronger? I know we haven't finished Nick McLeland's yet. We'll get to that next, but I just wanted to ask you, whose do you think so far was better? So we've heard the entirety of the defenses. We will hear a little bit more from the state, though. I'm not going to tell you my opinion. I bet you guys can probably guess it. So the court says, well, ladies and gentlemen, we're going to go ahead and take our lunch recess. While you're outside the courtroom, keep your minds open. You may discuss the evidence so far, but please only do that if all 15 of you are present in the jury room at the same time, and please don't deliberate. Gentlemen, bailiff says, all rise. The jury leaves. The court says, let's resume at 1 o'clock. Jody, you can go off the record. They come back. All right, we're back on the record, says the court. Oh, where's Mr. Rozzi? Mr. Baldwin says he had to run to the restroom. He'll be right back. Court says, and when he returns, are you prepared to proceed, Mr. McLeland? Yes, Your Honor. All right, Mr. Rozzi, are you prepared to proceed? Yes, ma'am. Let's bring the jury, please. Bailiff says, all rise. The bailiff says, or the jury comes in. The bailiff says, bailiff says, thank you. You may be seated. Court says, thank you, gentlemen. I'm just going to give you a minute to get all your things out for note-taking purposes again. All right. Well, as I indicated to you, the state has its rebuttal argument prepared for you, Mr. McLeland. Mr. McLeland says, thank you, Your Honor. The court says, could you turn your table mic back on, please? Go ahead. Mr. McLeland says, thank you, Judge. Ladies and gentlemen, it's been a very long 3 or 4 weeks we've spent together. You've heard a lot of evidence and heard a lot of testimony and seen a lot of evidence, and now's the time we hand the case over to you, and you're in the driver's seat, not the attorneys, not the judge. They don't decide the facts and the law. You decide what those are. The judge is going to give you instruction on what the law says, but you decide how that applies to the facts and the testimony. You're in the driver's seat. And so I'm not up here to tell you when you should be offended about things and when you shouldn't or how you should feel. I'm up here to tell you to surmise the evidence that the state has presented to you. Way back in the beginning, there were opening statements that we did, many opening statements in Fort Wayne, and then opening statements here. And the defense went through a lot of stuff and a lot of things that they said that the evidence was going to show. But I present to you that they haven't backed up those claims. I use the phrase that this is about bridge guy, a bullet, and a brutal murder. I said that a couple of times. I told you that I was going to introduce evidence of confessions that included detail that only the killer would know, and we've done that. The state has done that. The state's presented evidence to you of witnesses that were on the trail that day and witnesses that described a man that they see walking on the trail that day and on the high bridge that day. And they give a description of that man, and they all identify that man as Bridge Guy, which is really just reaffirming what Richard Allen said himself, that he was on the trails that day from 1:30 to 3:30, and that he was wearing clothes that matched the clothes that Bridge Guy was wearing. So those affirmations by those witnesses just reaffirm what Richard Allen tells you, and that he's on that bridge. We then have the video of Libby German's cell phone. It tells you the exact time that they were abducted, 2:13 p.m. Witnesses on the bridge and the trail after that are irrelevant, and abduction has already happened. The phone stops moving at 2:32 p.m. It's underneath the body of Abby Williams. Hard data. They want to say hard data. That's hard data from the phone. You get to the crime scene and this notion that, oh, since they didn't scream, it didn't happen. Richard Allen had a gun pointed at them, used the gun to execute power over them. We know they didn't scream, but we know Libby was crying. Blood outline of her tear on her face, scared, fearful, and all because of Richard Allen. We know that when he left behind his calling card, a bullet. And I don't understand and I don't comprehend how this is a magic bullet. It goes from the crime scene to the lab with Stacy Bozanovsky and Melissa Oberg to be tested, and she testifies in her expert opinion that bullet was cycled through Richard Allen's gun, a gun that he never loaned to anybody, that he never let anybody borrow, ammunition that he never loaned to anybody. And she told you why she thought, what she based that opinion on. The defense wants you to look at the pictures and say, look, these don't match. She told you. You can't see those pictures. I'm looking at a 3D image. Those are 2D images. Her results were even verified. The defense had an expert witness. He could have tested the bullet. He didn't. Not only that, he didn't write a report, didn't give any findings, nothing. I don't understand how that's a magic bullet. Magic in the sense maybe to the defense because it links Richard Allen to the crimes. I'll go with that. And then we go to the confessions. Throughout this case, the defense has repeatedly said words matter. Why don't Richard Allen's words matter? He said a lot of words to a lot of different people, his mom, Kathy, Dr. Walla. Detailed confessions to Dr. Walla. I laid in wait. My intent was to R the girls. I thought they were older than they were. I messed with the gun. I forced them down the hill, and I saw a van, and I got scared. So I walked them across the creek, and I slit their throats. Words matter. And this is not a stranger, Dr. Walla. He trusted Dr. Walla. You can hear that in the phone call to his mom. He played a phone call last week where he called his wife while Dr. Walla was in the room and confessed to his wife in front of Dr. Walla. He wanted Dr. Walla in the room. He trusted her. Or Dr. Walla was the one saying, "Tell her you did it. Go ahead. I'll dial the phone. Just tell her you did it." Maybe. I don't know. Just a possibility. Um, the evidence presented in this case shows that Richard Allen is Bridge Guy and that Richard Allen killed Abby and Libby. There are two victims in this case, Abby and Libby. Those are the two victims of Richard Allen. No, I'd say the third victim is Richard Allen being railroaded by the state. But they're more than victims. They're also heroes. Oh yeah, I remember how he's this is so stupid. Libby for making the video, the recording of Bridge Guy. Abby for concealing the phone for law enforcement to later find. And both of them for camouflaging the bullet that Richard Allen left behind. Huh? So they're heroes somehow in this story. Okay. Those pieces of evidence helped law enforcement find Richard Allen. I'm going to leave you with this. When Becky was on the stand, she mentioned that at one point Libby told her, "Someday I'm going to grow up and help police solve crimes." That's exactly what she did. And she brought Abby along to help her. Thank you, Judge. This is sick and twisted. I don't like how they used her like that and her love of true crime. Gross. The court says, "Ladies and gentlemen, I'll now present the balance of the instructions to you." So we're going to listen to the remainder of the instructions. She's not reading them a second time. She's giving them more instructions. So I was wrong in that part. So we will read this. So, ladies and gentlemen, I'll now present the balance of the instructions to you. Those are the last pages at the back of your packets. And again, I'm required to read these, so you may follow along if you wish with the copies that I have provided. All right. Juror 11 in seat 13, Juror 2 in seat 14, and Juror 9 in seat 15, you are instructed that you shall accompany the jury into the jury room and please pay careful attention to the deliberations of the jury. You are instructed that you may not participate in the deliberations unless directed in order to do so by the court. The defendant has entered pleas of not guilty, and the burden rests upon the state of Indiana to prove to each of you, beyond a reasonable doubt, every essential element of the crimes charged. The charges which have been filed are the formal method of bringing the defendant to trial. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told it is only necessary to prove that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Uh, Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced the defendant is guilty of the crimes charged, then you may find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you should give him the benefit of the doubt and find him not guilty. The burden is upon the state to prove beyond a reasonable doubt that the defendant is guilty of the crimes charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt that concerning the defendant's guilt, but it does not mean that a defendant's guilt must be proved beyond all possible doubt. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise either from the evidence or from the lack of evidence. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you weighed and considered all of the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. The state must prove each element of the crimes by evidence that firmly convinces each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. The rule of the law, which requires proof of guilt beyond a reasonable doubt, applies to each juror individually. Each of you must refuse to vote for conviction unless you are convinced beyond a reasonable doubt of the defendant's guilt. Your verdicts must be unanimous. Under the law of this state, a person charged with a crime is presumed to be innocent. This presumption of innocence continues in favor of the defendant throughout each stage of the trial, and you should fit the evidence presented to the presumption that the defendant is innocent if you can reasonably do so. If the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence. If there is only one reasonable interpretation, you must accept that interpretation and consider the evidence with all the other evidence in the case in making your decision. The defendant has not been required to present any evidence to prove his innocence or to prove or explain anything. The fact that charges have been filed, the defendant arrested and brought to trial is not to be considered by you as any evidence of guilt. You are the exclusive judges of the evidence, the credibility of the witnesses, and of the weight to be given the testimony of each of them. In considering the testimony of any witness, you may take any account his or her ability and opportunity to observe the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship with other witnesses or interested parties, and the reasonableness of the testimony of the witness considered in light of all of the evidence in the case. You should attempt to fit the evidence to the presumption that the defendant is innocent and the theory that every witness is telling the truth. You should not disregard the testimony of any witnesses without a reason and without careful consideration. If you find conflicting testimony, you must determine which of the witnesses you will believe and which of them you will disbelieve. In weighing the testimony to determine what or whom you will believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. The number of witnesses who testify to a particular fact or the quantity of evidence on a particular point need not control your determination of the truth. You should give the greatest weight to the evidence which convinces you most strongly of its truthfulness. During the program of this trial, certain questions may have been asked and certain exhibits may have been offered, which the court ruled were not admissible into evidence. You mustn't concern yourself with the reasons for those rulings, since the production of evidence is strictly controlled by rules of evidence. This is one that I would have a hard time with. Anytime something is objected to and sustained, I'd be like, why? Why did she not let that come in? I wanted to hear that. I would have a really hard time with this as a juror. You mustn't consider an exhibit or testimony which the court ordered stricken from the record. In fact, such matter is to be treated as though you never heard it. Nothing that I said during trial was intended as any suggestion of what verdicts you should find. Each of you, as jurors, must determine the facts and the verdicts. The evidence must be judged and considered from your memory of the testimony of the witnesses and such exhibits as may have been admitted for your examination. Transcripts of witness testimony will not be available to you during your deliberations. Materials which were reviewed by witnesses or mentioned by the attorneys that were not admitted into evidence will not be provided to you during your deliberations. The unsworn statements or comments of counsel on either side of the case should not be considered as evidence in the case. It is your duty to determine the facts from the testimony and the evidence admitted by the court and given in your presence, and you should disregard any and all information you derive from any other source. Your verdicts must represent the considered judgment of each juror. In order to return verdicts of guilty or not guilty, you must all agree. During your deliberations, you should not yield your individual judgment to a fellow juror just so you can return verdicts. However, it is your duty to impartially consider the evidence with your fellow jurors, to examine your own views in light of your discussions, and to consult and reason with your fellow jurors in a good faith effort to arrive at just verdicts. After you return your verdicts, you are under no obligation to discuss them or the reasons for them with anyone. After you've retired to your jury room, the bailiffs of this court will be in attendance, but they cannot be present in your jury room during any of your deliberations. Should you, at any time during your deliberations of the cause, leave the jury room, you must leave in a group and at all times be in the charge of the bailiffs. While you're absent from the jury room, you mustn't talk about the case among yourselves, with the bailiffs, or with any other person when you've agreed upon verdicts and such verdicts have been signed and dated by your foreperson. You will inform the bailiffs you've agreed. You will remain in the jury room until the bailiffs, on court order, conduct you back into the court, into open court, where your verdicts will be reviewed and read by the court. Neither sympathy nor prejudice for or against the witnesses or the defendant in this case should be allowed to influence you in whatever verdicts you find. I am solely responsible for assessing the penalty within a broad range of possibilities. The law has been written so that you may make your decision without being influenced by the apparent severity or leniency of the sentence. The court is submitting to you forms of possible verdicts you may return in this case. The forms will be supplied to you when you retire to the jury room for deliberations. Upon retiring to the jury room, you will select one of your members as a foreperson. The foreperson will preside over your deliberations and must sign and date the verdicts to which you all agree. The foreperson must return the verdict forms back into open court. The bailiff swears them in, or the bailiffs are sworn in, I think. The court says, all right, verdict forms. Ladies and gentlemen, take all of your materials and your papers. The bailiffs have your verdict forms and will bring in the evidence that we can bring into you. Bailiff says, all rise. The jury leaves. The court says, you may be seated. I'll show the jury out at 1:25. Are there any objections to the court's instructions as read, Mr. McLeland? No, Your Honor. Mr. Rozzi? No, ma'am. Please leave numbers with Jody so that we can find you if we have questions or if they want to see the evidence. You need to be within 5 minutes of the courthouse. Please don't leave the vicinity of the courthouse and drive to Logansport again. I really need to have access to you immediately and have your input if they do have questions or they want to review the evidence. We will be clearing the courthouse and locking, or not the courthouse, but the courtroom, and locking the doors. If the jury needs to get out of jury room for whatever reason, because it gets kind of cramped and small in there, or they want to stretch their legs, we'll be using the courtroom for that purpose. So we'll be clearing the courtroom and locking the doors for that. If they want to review the evidence, I think both of you invited them to listen to things and watch things. I'll advise counsel and I'll expect you to be here, and the defendant will be brought in as well. I would ask, though, that we'll probably have you back in the courtroom so that you can observe that process while they review whatever evidence it is that they'd like to review. Mr. McLeland says, Judge, we talked at some point about waiving counsel's presence. Is that something the court's willing to consider? I don't need to be here. I suppose I'm willing to waive it if they want to review evidence. Just throw that out there, Judge. Mr. Baldwin says, we don't have any issue with that. I mean, as long as we're invited, we can have the opportunity, and I know we would be. Court says, of course you would be. Mr. Baldwin says, and the court says, if you'd like to be here, then I would require the state to be here. Mr. McLeland says, sure, Judge, I understand. The court says, and then we would bring Mr. Allen in as well. Mr. Baldwin says, okay. The court says, okay, all right. Is there anything else that we need to do on the record before we clear the courtroom? Mr. McLeland says, or Mr. McLeland, No, Your Honor. Mr. Baldwin says, Judge. Court says, Mr. Rozzi. Mr. Baldwin. Mr. Baldwin says, sorry. These are unusual, with sequestration. It's a little bit unusual. Does the court have an idea of, will they just go all the way through, but if it's midnight and they want to go to bed, or is that the manner in which the court says, what is the schedule? Is that what you're asking me? I guess so, yeah. The court says the schedule would be they're out right now and selecting a four-person, I presume. I'm anticipating letting them go back to the hotels around 4 o'clock, and that they would then reconvene tomorrow morning around 9 o'clock. Oh, okay, thank you, says Mr. Baldwin. The court says, and then they go until 4 again and reconvene. We will be working Saturday, much as we've been working Saturdays in the past. We will not be working Sunday. Everybody needs a day off. And the jury will not have access to their electronic devices. They will not have access to their families in that time frame as well. So I'm sure I just want them to continue to work. Mr. Rozzi says, so 4 o'clock would be kind of the closing hour unless they communicate to the bailiff that they want to keep at it. Yes, says the court. Mr. Rozzi says, okay. Court says yes, Mr. Rozzi says, because I've had those circumstances. Court says, yeah, and they want to keep going. Mr. Rozzi says, yeah. Court says, and if that's the case, they'll keep going. I will stay at the courtroom with my court reporter as well, just in case they do have questions and I need to contact counsel. Rozzi says, okay, to get your input on how, the court continues, to get your input on how you want me to answer questions and if they want to see any evidence. But I would absolutely contact counsel to let you know if they have questions, if they want to review the evidence, and if you want me to contact you when they go home back to the hotels, I'm happy to do that as well if you wish. Mr. Rozzi says, that would be great, just so we know when the day is over. Yeah. Court says, just so that just you're kind of off the clock. Mr. Rozzi says, yeah. Court says, okay, anything else? But she can be pleasant. She can do nice things that make her seem human. But I don't think she is. Mr. Baldwin says, no, nothing else. Mr. Rozzi says, I left our numbers with Ms. Williams. Court says, okay, so do we need to get numbers for the state then? We'll do that, Judge. Thank you, says Mr. McLeland. The court says, all right, just thank counsel for your excellent final arguments. Appreciate the manner in which you presented that information to the jury. Very well done. And we are off the record, Jody. That's a really weird comment. Why? They were well done, and she's appreciative of the manner in which they were presented. I don't know what that means. There is a lot of argument about, not argument, and it's not a lot. I guess I'll go through it. I didn't want to, but might as well. All right, so there are jury questions. I don't know if I'm going to have time to record all of it. Hold on. Let me see if there's anything really significant. Let me skim it real quick. Okay, so basically, the jury did come back. They wanted some evidence. They wanted some videos or something. And then the court finds something out. So the attorneys get a little bit scolded. So this is the next day, I think. So they publish something for the jury and then they tell them, okay, go back to your deliberations. And then the court says, all right, well, counsel, thank you for coming back. And I just have a couple of things that I would like, if you'd like to come closer to the well of the courtroom, please. And Mr. Allen as well, gentlemen. Yes, in the well of the courtroom, please. And Nathan, you can give those to Jody, if you would, please. Thank you. All right. Well, I'll show the jury back out to deliberate at 1:38. I'm just going to remind counsel of the gag order that was issued by this court on December 2nd of 2022. I've pulled it up in the electronic file and in pertinent parts. It reads counsel for the state of Indiana and the defendant, as well as their professional staff and other personnel, law enforcement officials, court personnel, coroner, and all family members are prohibited from commenting on this case. How can you cannot make such a broad gag order like that? You can only gag the attorneys and maybe witnesses. But I don't know. You're not supposed to be gagging whole family members, like whole families. That's not how it's supposed to work. But continuing on with her, she's prohibited all these people from commenting on this case to the public and to the media directly or indirectly by themselves or through any intermediary in any form, including any social media platforms. Yesterday, I communicated directly with Mr. McLeland and with Mr. Rozzi too. I don't recall the time, but it was by phone to inform both sides that the jury wanted to view the first interview, the enhanced video, and the audio, and the only individuals that were provided with that information directly was, again, Mr. McLeland and Mr. Rozzi. I was quite surprised last evening when I was watching TV to see that this specific information ended up on national television. Then, this morning, as I excused all of the staff attendants to our proceedings here this morning, I noted that it was about 10:03 when I asked the state's investigators and extraneous folks and the defendant's extraneous investigators and individuals to leave the room. I noted that that was at 10:03, and at 10:15 this morning, Bob Mata, who is apparently a social media content creator, is posting on his Twitter account that the jury wanted to see the specific videos that we discussed previously and the specific audios that the jury wished to see. Bob Mata from the Defense Diaries. If this dog could sit still, I'd have a better day. He is just all over the place and he's driving me crazy. Can you stop hitting the mic and getting in my way? Anyways, um, Bob Mata from Defense Diaries is now in the transcript because he posted something on Twitter. Again, the only people that were aware of this information were the attorneys and their professional staff. Now, I've observed Mr. Mata here in the courtroom. He's been here for several weeks and he has been interacting with multiple members of the defense staff, Mr. Hoffman, Mr. Baker, Ms. Auger, Mr. Baldwin. I don't know what those conversations consist of, and I don't particularly care what those conversations consist of, but Mr. Mata is clearly sharing information that only counsel would have. But you said it was on the news before, so how can you say that? Mr. Mata might have had it from the news, right? There's a violation of the gag order, folks, and I have concerns. You've seen the folks outside the courthouse with their signs and podcasters and YouTubers. God, the judges hate podcasters, YouTubers. They hate us because, mainstream media does too, because we can say the things that, mainstream media can't. And because mainstream media is controlled by the government anyway, so it's not really a question. Late night, the jury's van was followed. I haven't shared that information with counsel, and I will not be sharing any further information with counsel about the jury, about when they're leaving this building, when they are not leaving the building, because I clearly can't trust that that information will stay with counsel and their professional staffs, because it's getting out to other individuals. I don't know if it's Mr. Baker, Mr. Hoffman, the attorneys. I don't know, but I will not be informing counsel when the jury leaves the building, and I will be informing counsel strictly of they have a verdict. So you're just going to let them think that the day just ends and or just continues to go on and on. The whole point of you telling them when they left was so that the attorneys knew that they could go home for the day. So you're not even going to give them that courtesy. Got it. Gentlemen, you may take Mr. Allen back to Cass County. I expect compliance with these orders, blah, blah, blah. Thank you, Judge, says McLeland. Diener says, thank you. Baldwin says, Judge, did you still want us 5 minutes away? Yes, please. They go off the record. Something about waiting for Kathy to arrive. Is there a verdict yet? This is basically just everybody coming back. I don't know if I'm at the. Hold on. Let me pause for 1 second. Okay, I just wanted to confirm these are the verdicts. So November 11th, everyone is brought back because the jury has reached a verdict. So basically everybody just comes along in, everybody's in the courtroom. The The court says, all right, the record will reflect that Mr. Rozzi and Ms. Auger have returned to the courtroom. The jury has indicated that it has verdicts. Just as a reminder, counsel, please turn your phones off, and I trust that the bailiff has already indicated to you that phones should be off. Ladies and gentlemen in the audience, I'd ask that you remain respectful to the rest of these proceedings. This has been a long haul for the defendant and his team, as well as the state and their team, and they don't deserve to have any outbursts in this courtroom. As you can see, there's a lot of uniformed officers in the courtroom, and they have the court's authority that if you cannot conduct yourself in an appropriate fashion, you will be asked to leave, and if you refuse to leave, you will be escorted out of the office out by the officers. Please don't do that. Please don't do that to Mr. Allen. Please don't do that to Mr. McLeland and the state. I expect you to be quiet. Regardless of whatever the verdict is, people are not going to be happy. You can take your unhappiness outside. Mr. McLeland, is the state ready to receive the verdicts? Yes, Your Honor. Miss Rozzi, is the defense ready? Yes, Your Honor. Gentlemen, says the court. The bailiff says, all rise. The jury enters the room. The bailiff says, thank you, you may be seated. The court says, all right, juror 30 in seat 30. I've been informed you are the foreman of the jury. Is that correct? Yes. And has the jury reached verdicts? Yes. If you would pass the verdict forms to the bailiff, please. All right, the verdict reads, we, the jury, find the defendant, Richard M. Allen, guilty of count 1, felony murder of a felony dated 11/11/2024, signed by our foreman. Verdict, we, the jury, find the defendant, Richard M. Allen, guilty of count 2, felony murder, a felony, same date, also signed. Same thing for counts 3 and 4. I'm not going to read that. Does either side desire a poll of the jury? No, Your Honor, says McLeland. Yes, Your Honor, says Baldwin. The jury says, all right, juror 39 in seat 1, are these your verdicts? Ma'am. Yes. Juror 19 in seat 2, are these your verdicts? Yes. Juror 1 in seat 3, are these your verdicts? Yes. Juror 54 in seat 4, are these your verdicts? They are. Juror 42 in seat 5. Yes. 21 in seat 6. Yes. Juror 36 in seat 7. Yes. Juror 8 in seat 8. That's convenient. Yes. Juror 1B in seat 9. Yes. Juror 45 in seat 10. Yes. Juror 30 in seat 11. Yes. Okay. Juror 16. Yes. Is counsel satisfied? Yes. Court says, all right, well, ladies and gentlemen of the jury, on behalf of the court and the parties, I'd like to thank you very much for your service in this case. I know you've made a tremendous sacrifice for the state of Indiana. I'm very grateful for your service. With that, you are released and discharged. Gentlemen. Bailiff says, all rise. The jury leaves. The court says you may be seated, Mr. Allen. Consistent with the jury's verdicts, the court will enter judgment of conviction on counts 1, 2, 3, and 4. I'll refer this matter to the probation department. I've been advised by the local probation department that they are unable to complete a pre-sentence investigation report. I've been in communication with the probation department from my home county, Allen County, and have discussed the possibility of a pre-sentence report that the Allen County Probation Department could complete. Defense intends to present any sentencing memorandum. I don't know how long we'd need for sentencing, so in anticipation of a potential verdict, I obtained dates for the local court to see what would be available. So I just need some guidance from counsel as to how long you think you will need for sentencing, what type of time you're looking at. Mr. Rozzi says, Judge, Mr. Rozzi says, can you give us the dates? I thought you said you had some dates in mind. She gave me some. She gave me December 12th, 13th, 20th, blah, 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 blah. Any of those December dates okay? Says Mr. Rozzi. The court says, and she gave me consecutive dates because I don't know if you need a day. And Mr. Rozzi says, I don't think we're going to have, volumes of evidence to present. I would say that the 12th date may be good, that 12th and 13th, just in case. What about the state? We'd waive 30 days in that regard. I'm sorry, says Mr. Rozzi. The court says, okay, thank you. I was going to ask if you'd waive 30. I guess you need 30 days until sentencing. I don't know what that means. Okay. Judge, December 12th, we have winter conference starting the 9th, 10th, and 11th. Okay, says the court. McLeland continues, and I had to skip summer conference, so I gotta go so I can get my CLEs in. Court says, okay. Mr. McLeland says, for this year. And so I hate to have to come back the very next day to coordinate with family and those kind of things. I think the 12th was one of the dates that you had mentioned. Yes, and the 13th, says the court. McLeland says, and so those days aren't great from the state's perspective. Okay, if that's all they're doing, then I'm just going to skip this. They finally decide on the 20th. Do, 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 do. All right, so December 20th, we can start at 9 o'clock. Mr. Rozzi, with your permission, I will have Mr. Zimmerman, my chief probation officer, contact you directly to see what the time frame would be as far as if you wish to be present during the interview of your client. I don't know how they'll conduct it. I know that that county jail that he's currently being held in has the ability to do video, but I would assume that my probation officer is going to want to come and meet Alan in person. Zimmerman? Yes, sir. Okay. Eric Zimmerman. Okay. Yeah, thanks. That's fine. You have my number. So court says yes. And I'll have him, Mr. Rozzi says, if he needs to call me, that's okay. Court says, okay, all right. Is there anything else on behalf of the state of Indiana, Mr. McLeland? No, Your Honor. Anything else on behalf of the defendant? No, ma'am. All right, ladies and gentlemen, I'd like to thank you for a very well tried case. And those of you in the audience, thank you very kindly for maintaining your composure. Jody, you may go off the record, and that concludes the end. That's it. But we are going to read the sentencing, so don't go anywhere. It's only it's 35 pages, so it's not only, but I wanted to get it all in one episode, so we're going long today. But I got to take a break and let the dogs out, so be right back. All right, let's get to it. So, good morning, ladies and gentlemen. Remember, this is now December 20th, so it's been over a month since his sentence, or since he was given his verdict, which was November 11th, and now it is December 20th. So, the court says, good morning, ladies and gentlemen. We are on the record in the state of Indiana versus Richard Allen. I'll show the defendants here in person with counsel. The state is here by the elected prosecutor and his attorney, or deputies. We are here for sentencing. Thank you for the sentencing memorandum submitted by counsel. I believe it was yesterday or Wednesday, excuse me. Are we ready to proceed, Mr. McLeland? McLeland says, yes, Your Honor. The court says, Mr. Rozzi, yes, ma'am. The court says, Mr. Allen, for the record, would you state your full name and age for me, please? Richard Matthew Allen, and I'm 52, says the defendant. The court says, and you are the same Richard Matthew Allen who was found guilty following a trial by jury? Yes. You're here with your attorneys, Mr. Rozzi, Ms. Auger, and Mr. Baldwin. Are you satisfied with the manner in which you've been represented? Yes. Have you seen the pre-sentence investigation report? Yes. Have you had a chance to review that report and to speak with your attorneys about it? Yes, I have. Are there any additions or corrections to make to the report? Very, very minimal. Nothing of... What would those be, Mr. Rozzi? Nothing important, says the defendant. Mr. Rozzi says, Judge, just... Excuse me. The defendant says, sorry. Mr. Rozzi says, just referencing page 2 of 9 at the top, the arrest date as reflected in October 28th, and it's actually October 26th. And so we would just ask that you add 2 more days to the credit time, which would increase from 784 to 786, and that's the totality of the charge. The court says, so with the correction of your jail credit, Mr. Allen, the pre-sentence report is as accurate as possible? Yes, ma'am. Mr. Rozzi, sentencing argument. Mr. Rozzi says, Judge, the defense would rest on the assertions in the memorandum we filed in the court. The court says, Mr. McLeland, Judge, the state would like to call one witness to testify, to the stand to testify, and then we have a series of 6 unsworn statements from the victims' families for the court to consider. Okay, says the court. McLeland says, and so the first witness the state would like to call Lieutenant Jerry Holman, please. So McLeland says, "Thank you, Judge. Direct examination of Jerry Holman. Mr. Holman, will you state your name, please?" "Jerry Holman." "How are you employed?" Remember, there's no jury here, so this is all for the court. I just wanted to remind you that. The jury's been discharged at this point. "How are you employed?" "I'm employed with the Indiana State Police." "And you became involved in this investigation in the death of Abby and Libby back in February 14th of 2017, is that correct?" "Yes, I did." "A day after they went missing?" "Yes." "And since that time, you've been heavily involved in the investigation throughout the 8-year period, is that correct?" "I and many law enforcement officers from many different agencies have poured our hearts and souls into this for the last 7 years and 10 months. Yes." "Well, you didn't do it well enough because you convicted the wrong guy." "And you also sat through trial here at counsel table with me. You were able to hear and see all the evidence that law enforcement gathered against Richard Allen, is that correct?" "I have." "And you had the you had the opportunity to observe in detail the crime scene photos as well as that, right?" "Unfortunately, yes." "And safe to say you've investigated several murders throughout your career as a law enforcement officer." "I have." "And have you investigated murders that deal with children?" "A few, yes." "And how does this compare to those other murders that you've investigated?" "This one was very brutal. Mr. Allen laid in wait. He stalked the girls. He kidnapped. He humiliated them. He treated them like animals. He used a gun to control them. It was obvious his intent was to sexually assault them or molest them until he got interrupted. And then he forced them to take their clothes off. At some point, made them walk across a frigid creek, again treated them like animals, obviously killed one in front of the other. I can't imagine the fear and anxiety that they went through to watch." This guy's good. He should write uh fiction. Should write fiction novels. "And then he covered them with sticks and left them there alone and went on to live his life like it never happened." Very dramatic rendition there of what actually took place. "And throughout your investigation, you spent a lot of time in the Delphi and Carroll County community. Is that safe to say?" "I have." "And you interviewed several people who live in this community." "Yes, I have." "Several people who are from this community." "Yes." "And did you see the effect that this murder had on the community?" "I did." "Can you tell me a little bit about that?" "Because of the brutality and the heinous crime that he committed, I think it definitely put a lot of fear and anxiety in the community. Family members were afraid, or members of the community were afraid to allow their family members to go out, so they took extra precautions. And because of Mr. Allen allowing his attorneys to use unethical strategies by falsely accusing you of withholding evidence and falsely accusing police officers of being corrupt and lying, that also had an impact on the community, that the ones that supported the prosecution, they were getting threats. Family members of the victims were getting harassed and threats. Maybe they shouldn't be so suspicious. Like I said, community members were getting threats. I don't know how many calls I received on people being harassed because they were supporting prosecution in the community. You and your family have been harassed, and many law enforcement officers and their families have been harassed and have received death threats because Mr. Allen allowed his attorneys to be unethical." What? First of all, they didn't do anything unethical. Secondly, Mr. Allen allowed them to. He allowed them to be unethical. Okay. Mr. Allen is fighting for his life right now because he's being charged with crimes he didn't commit, but he's telling his attorneys to go be unethical. So, given everything that you learned through this investigation, everything you've learned through the case, do you have any recommendation of the court as to what is an appropriate sentence for Mr. Allen? I do. I believe because he's so manipulative and persuasive, I think he's a danger to society. I think his lack of remorse, he says he wants to apologize to the victims' family members, but he hasn't yet. I hope today's that day. He also has used religion to manipulate his wife, his mother, and corrections officers. I hope he really has found God. I hope he confesses to all of his sins, and I hope he is forgiven someday. But I think it's just a tactic that he uses to manipulate people to get what he wants, i.e., when he breaks his iPad, he wants a new iPad. He wants transferred from to a better facility. He wants visits with his wife. He uses those manipulation tactics to get what he wants. Really, no one thinks Richard Allen is like that manipulative psycho person that you claim him to be. So, everybody that you've seen and heard, do you believe he's a danger to the community? I do. I believe that he exhibits all the traits that he would definitely be a danger and pose threats to people if he ever was able to be back in the community. Is there anything else you want the court to consider when fashioning a sentence for Mr. Allen? No. Mr. McLeland says, I don't have any other questions, Judge. The court says, Mr. Rozzi, no questions. The court says, thank you, Lieutenant. You may step down. Mr. McLeland says, Judge, the state has no further witnesses, but I do have, as I said, 6 family members that would like to make an unsworn statement to the court for their consideration. I'd like, if the court would allow me, I'd like to call them up at this time and allow them to make that statement. You may, says the court. Mr. McLeland says, thank you, Judge. State would first call Carrie Timmons. Carrie, before you get started, I'm going to let you know that microphone, I don't believe it amplifies, and so I'm going to need you to speak up in your best voice so that everybody can hear you, including the judge and the defense and the audience, okay? I'm going to ask you a few preliminary questions just to get your name and stuff on the record, and then I'll let you take your statement, make your statement. So can you state your name, please? Carrie Timmons. And will you spell that for the record? She does. And you have a statement that you'd like to make to the court for consideration in sentencing, is that correct? Yes. Okay, go ahead. Ms. Timmons says, I struggled for weeks over writing this because I'm honestly not sure how to explain the path of destruction left in the wake of the decisions made by Richard Allen on February 13th, 2017. I think this is Libby's mom, right? That day changed all of our lives in so many ways forever. Libby was always my go-to for advice. She somehow would always know exactly what to say in a situation, and I have no doubt that she is currently holding my pen. I had no problem getting the word out when he was just the bridge guy and had not been identified, but I honestly don't know how to process the fact that a husband and a father is capable of the horrendous acts of brutality inflicted upon our beautiful children. I was totally blind to the fact that such evil existed. I don't know which is worse, knowing or not knowing. The last 2,867 days have been absolute hell for Libby and Abby's family and friends. Next week, we should be celebrating our birthdays together. She would be 22 and she should be here. I quit celebrating after her 14th and my 39th. I can't help but see her grin at that, understanding the anxiety that she knew I had about turning the dreaded 40. As Libby's mom, I am left with so many what ifs. I'm left without memories of her growing up, getting her driver's license and her first car, her first job. She didn't get to graduate and go on to college. We were cheated out of seeing her be the best auntie. She doesn't get to fall in love, get married, and have babies. She was robbed of all of the opportunity to experience life and fulfill all of the dreams and aspirations that she already had at such an age. I can't even put into words what I feel like to see the our other parents and other children get those things. For their lives to go on makes no sense to me. I shouldn't be jealous of them, but I am. I can't understand how life managed to go on for everyone else while mine stopped. Instead of those memories and milestones, I am left with this massive grief, a literal hole in my heart, broken relationships, shattered hearts, and broken dreams. I struggle daily with guilt, crippling anxiety, complex PTSD, and severe depression, but continue to persevere in a world I don't want to live in without her. My daughters were robbed of their big sister, their childhood, their innocence, and life as they knew it. They had to grow up, through so much turmoil. My daughter Alexis turned 11 3 days after her sister's body was found on my grandmother's birthday. Birthdays are very hard for all of us. I'll never understand how you were able to get away with this for so long. How can such evil live in plain sight, continuing to walk down the streets lined with your picture, making a mockery of law enforcement, our families, the community, and especially Libby and Abby for nearly 6 years? Only Richard Allen has those answers. And since you've claimed remorse and a need to apologize, I won't hold my breath waiting, but I deserve those answers. Libby and Abby deserve the entire truth to come out, and I'm all ears. Please give me your visitors list. I'll listen, or put me on your visitors list. I'll listen. While there will never really be justice or closure and nothing will bring my daughter back, I am so very proud of her for not only exposing her and Abby's killer, but also for bringing much attention needed to so many cases near and far. This tragedy hasn't completely stopped Libby from accomplishing at least one dream from beyond her grave. Her courage and strength will live on as she guides us through this lifetime until we meet again. She will always be my sunshine. Mr. McLeland says, Carrie, is there anything else you want the court to know? No, thank you. Mr. McLeland says, all right, thank you. The court says, thank you, ma'am. Mr. McLeland says, okay. Okay to go forward, Judge? You may, she says. Mr. McLeland says, okay, thank you, Judge. Judge, the state would call Josh Lank, please. Judge, do you want him at the podium or the witness stand? He could, whatever is comfortable for you. McLeland says, okay, all right. Will you state your name, please? Josh Lank. And will you spell your last name for the record? He does. And how are you related to the victims? I am Libby's first cousin. Okay, and you had a statement that you'd like the court to consider for sentencing. Yes, sir. Okay, go ahead. Good morning, Your Honor. How are you? Good morning. I'm well, thank you. Weird. He says, first, I would like to start off by thanking the prosecution team and law enforcement. Without you guys and everyone involved in this case, bleh, the countless hours of you guys' time that was dedicated to this case, I truly can't thank you guys enough. You can tell from the beginning that this case was very important to them. That's because I think they know who did it and they're hiding it on purpose. They did everything they could do to find justice for these two beautiful girls. I would also like to thank our little community. You guys have been so kind to our family with the love and support you have shown us, from painting the town teal and purple to feeding us every day throughout the trial. I seriously can't thank you guys enough. Our town may be little, but this goes to show that in a time of need, our community pulls together. Libby was my first cousin, but the bond we had was a brother and sister bond that nobody could break. When we were younger, we were together every day. It was always Kelsey, Libby, my brother, and I. We would ride to the bus to my grandma's after school, and you would never know what kind of trouble we would get into. Libby, she was one of a kind. She would give the shirt off her back to someone that she thought needed it more than her. She was always trying to find ways to help people and make things easier on everyone. She truly was going to do great things in life. I will forever remember Libby by the amazing memories we made and not how Richard Allen left them on February 13th, 2017. He took so much away from both of those girls. They had amazing lives ahead of them. The pain he has put both of our families through could never be forgiven or forgotten. The things we had to see, we will never be able to unsee, all because of him. This man has made my life and my family's life a living hell for the past 8 years. Now it's time for your life to be a living hell. 23 hours a day, no communication, isolation from the world until you die. Okay, buddy. Slow your roll there. That's not how the world is supposed to work. Even if he did do it, that's not how we punish people. That's not how people get. That's not what we do when people murder someone in our society. We don't just throw them in a cell and never let them communicate with anyone for the rest of their lives until they die. Richard Allen took two amazing little girls with so much life ahead of them from my family and the Williams family way too soon. And for his actions, I hope and pray he lives the rest of his life thinking of the mistakes he made that day. I would like to leave you with this. God doesn't have a place for sick, twisted-minded individuals like Richard Allen. The devil has a special place in hell for him, and I hope the prison community can get him there quicker than the sentencing. This dude straight up called for prison death, prison murder. He wants someone else to take Richard Allen out in prison. He is a dead man walking. Judge Gull, I ask you take into consideration the max sentences with no parole. There should be no way this man has a chance to get out of prison and be able to have the ability to do what he did. Granting him no parole will solidify that. Thank you, says the court. Thank you, says Mr. Lank. Mr. calling for prison murder Lank. Mr. McLeland says, Judge, the state would call Diana Erskine, please, or Diana, whatever I said, Erskine. Sorry. Will you state your name for the record? She does. And will you spell it? She does. How are you related to the victims? I'm Abby's grandmother. And you have a statement you'd like to give to the court for them for the court to consider for sentencing? Yes, ma'am. Or, sorry, yes, sir. Yes, sir, Mr. McLeland. Go ahead, please. Good morning. Good morning, says the court. Before I read my statement, I would just like to say, on behalf of our family, this is not a day of celebration. We will not be going home and toasting champagne or high fiving each other. This is a day of great sadness for all the families that are affected by this crime, all of the families. I find it impossible to share how this crime has impacted my life without talking about Abby, my first and only child. She brought so much joy to our family and held so much promise in her short life. She was especially kind to young children and elderly people and was often surrounded by both in our home. Her favorite phrase was, Do you need any help? A kid's favorite phrase is, Do you need any help? I'd like some verification on that. Yes, Abby, I sure could use your help right now. The first word that comes to mind when I think about February 13th, 2017 is terrified. Abby was not bold or brave, especially when it came to strangers or the dark. This is the word that wakes me up in the middle of the night, knowing what she faced, what she felt, what she suffered, what she saw in those final moments of her life. The next word that enters my mind, especially since the trial, humiliated. Abby was a shy girl who blushed easily. She never dressed in a way that was revealing or drew attention to her figure. She would have been devastated by the number of people who have seen her in the most vulnerable state. I cringe every time I think about the photos that were not only shown for the purposes of the trial, but have been shared some sort of sick propaganda. Abby has clothes on. What are you talking about? Abby had clothes on. What is she talking about? Humiliated. Libby's the one that didn't have clothes. So why is Abby humiliated? I don't understand this. Every detail of her final moment reveals a nightmare, one that we will relive involuntarily for the rest of our lives. Mutilated. Our sweet Abby Williams suffered first at the hands of a murderer and then to the process of an autopsy. I understand the medical and legal necessity for an autopsy, but until this trial, I was naive as to how invasive this procedure was. How will I ever erase the mental images I now live with? I could have left during this or any of the portion of the trial that was so graphically horrific, but Abby didn't get that choice. Her last words that I heard recorded on Libby's phones was, Don't leave me up here. Are we sure about that? Libby didn't leave, so I didn't leave. The last time I saw Abby, she and Libby were laughing and walking out the back door, her arms full of the craft supplies they planned to use. I was washing dishes and called, Have fun. To this day, I have so much sadness for not stopping to hug her. The anxiety the anxiety I feel every time one of my grandchildren leaves or I leave them is a lasting reminder of losing Abby. Every day since the day Abby was murdered starts the same. I wake up, make the bed, look at the clock, and calculate how many hours I have until I may return to it. I pray, breathe, make the most of the time that I have, knowing that I have now lived almost 5 times Abby's lifetime on Earth. Every night I climb back into bed, look at the clock, calculate how many hours I have left to sleep. Unfortunately, sleep is not an escape, but more often a task. I pray for a good dream, a visit with my loved ones who are waiting for me with Abby in heaven. Nightmares come anyway, and I seldom sleep throughout the night without waking at least once. Then begin the what ifs and the if onlys. As I watch Abby's friends grow up, graduate from college, choose careers, and even begin having children, I can't help but wonder who she would have become in her life if had if it hadn't been taken. How many great grandchildren were murdered that day as well? How do we keep living and loving without her? I will never be the same person I was before Abby's murder. I grieve the life I used to have. I feel sometimes that my own family has been cheated out of the version of me that existed before the crime and the me that many people will never know. I am grateful for my life. I owe my survival to my faith in God. Richard Allen took Abby's life on earth, but she has already given her heart to God. Believe that. Thank you, ma'am, says the court. Mr. McLeland says, Judge, the state would call Eric Erskine, please. Sir, if you would state your name. Eric Erskine. Will you spell your last name for the record? He does. And maybe a silly question, but what's your relation to the victims? I'm Abby's grandpa. And you have a statement that you would like to give to the court for them to consider during sentencing. Is that correct? That is correct. Go ahead, sir. Writing and speaking about this tragedy is very difficult. I'm not very articulate or creative when it comes to the spoken and written word. I'm kind of a bolt and wrench kind of guy, but I'll do my best to keep it brief. The effects and the loss of Abby these past 7 years in our family is beyond words. How this has impacted each of us in our daily lives is difficult to process or explain. Each family member was affected differently, but overwhelmingly the same, if that makes sense. The loss of Abby was like losing a limb that'll never grow back. There's an empty spot or hollow place. This process has been similar to a wound that scabs over but consistently gets torn off, doesn't ever seem to heal. Thousands of times, the possible scenario of the girl's last hour on this earth has been replayed in my mind thousands and thousands of times. What was seen and heard in this trial only affirmed some of my most horrific thoughts. I'm thankful for God's grace in our lives that has carried us through these dark days. The effects of this horrendous crime has not only been a huge impact on our families, but has impacted this town. Not sure if we'll ever get back to normal from the dreadful murder of our girls. The impact of the girls' classmates at Delphi School was profound. Some are still in recovery from the trauma from this heinous crime. The horrific and senseless act by Richard Allen on February 13th, 2017, may have stolen our future and what might have been with Abby and Libby, but you, Richard Allen, will never take away our memories or the legacy of these girls. Something else that I'll never be able to understand is how, after lying in wait and conducting your premeditated plan to have your way with our girls, how could you continue to go about your daily routine like it never happened? How could you do that? I'd like to take a moment to set the record straight on a couple things that you, Richard Allen, have said. Richard, you said you found God. I hope you have. The fact is, God has been near all the time. He was not lost. You were. God was here before the earth was created, and you can read about it in Genesis. Matter of fact, God was there on February 13th. You chose to live a life void of God and full of sinful desires. The book of Romans speaks of those. Some refer to this as a reprobate mind. The girls knew God. They accepted him at Bible school and church camp. I have no doubt they're in a better place. God gives each of us a free choice. The book of Deuteronomy speaks of it. In a moment of selfish desires, you made unconscionable decisions that is beyond my comprehension. Part of the Christian conversion process, which you admitted to, brings forth a change both in physical and spiritual. Part of that growth process comes accountability. Nearly 100 different scriptures that I'm aware of speaks of this. However, you chose to remain silent. When it counted most, you could have set the record straight. Scriptures are very clear. At the end, everyone will be judged by the Creator for their deeds and their actions. In closing, since the beginning of this journey, I said I trusted the system. I've had faith in the body of work of our law enforcement and the prosecution team to do what's right on behalf of our girls, our families, as well as our communities to bring justice for all. Now, Judge Gull, we place that same trust in your decision making authority to do what is right based on the laws of the state of Indiana. I believe your training and experience has prepared you for this task. You wouldn't have been selected to oversee this trial if you were not qualified. Thank you, ma'am. A little buttering up to the judge. Never hurt anyone, right? The court says thank you. Mr. McLeland says, Judge, the state would call Becky Patty. Please, will you state your name for the record? Becky Patty. Will you spell your name for the record? She does. How are you related to the victims? I'm Libby's grandmother. And you have a statement that you'd like the court to consider for sentencing? I sure do. Okay, go ahead. Honorable Judge Gull, where does one start? How does one explain the effect of how one choice a person makes has on an entire family for generations to come? I don't think one can really explain it and do justice. There's not enough words in our language that begins to paint the picture of the grief we live with each and every day. Richard Allen was an adult and he should be held accountable for the choices he made on February 13th, 2017. He chose not to go to lunch with his mom and sister. Instead, he chose to drink beer for liquid courage. He chose to lay in wait for his victims to order them down the hill. He had the opportunity to let Libby and Abby go when the white van drove by, but he chose not to. So instead, he chose to take them around the creek where he viciously murdered them, making sure they were dead before he went home and continued his life. Richard Allen viciously and heartlessly stole the choice to live from Abby and Libby that day. He was a coward and didn't want to be held accountable for his heinous choices and actions, so he just killed them and went home. I guess in his eyes, he was nice enough to make sure that they were dead before he left so that they wouldn't suffer. A few days later, he developed photos for our family that would be used at Libby's funeral. He stood there watching my family members as they struggled to keep their composure while dealing with unsurmountable grief and preparing for the unthinkable that lay ahead, not blinking an eye, no remorse. I wonder what he was thinking. That he was an innocent man and he felt sorry for you. Now he probably doesn't feel that way so much. Our lives turned upside down that day, never to be the same again. Abby and Libby, two young teens, with their entire futures ahead of them, they never got the opportunity to make their marks in the world. He stole that from them. Libby never got to go to prom, graduate, go on dates, go to college, get married, or start a family. She never got to be the best aunt ever. He robbed us all. The world was robbed of what could have been. All the while, he went on living his life. He was able to walk his daughter down the aisle on her wedding day, giving her away. I wonder, did he even think about our girls at all while walking her down the aisle? Our families will never get the privilege of watching Abby Williams or Libby German walk down the aisle. He took that from us. The impact of Richard Allen's choices made that day has haunted our families for almost 8 years and continue even now. Because of choices he made and his subsequent arrest, he was appointed 2 lawyers to defend him. Those lawyers have done nothing but twist the knife around and around in our wounds that Richard Allen caused that day. This is why I think the families might be involved in some form or fashion. Why are you blaming the defense attorneys for pointing out facts in the case? Why are you not looking at the investigators who lied multiple times in this case and hid everything from the defense? Hid everything from the jury. That was Rozzi's whole closing. We didn't hide everything from you. We gave that to you. The state hid it from you. How are these families so blinded by their grief that they can't see the truth? I just don't understand it. I feel bad for them. I feel sorry for them for their grief. If it is truly real, if they weren't involved in their own daughters or granddaughters or whoever, demise, I think it's possible. I think the Patty family is a powerful family in the Delphi area, and I'd be looking into Odinism on their end to see if there's any ties to that, or Freemasonry, or anything of those, some kind of secret society type of thing. That's what I'm thinking is happening under, you know, undercover happening, out in the open, but undercover at the same time. It's the people of the town that sacrificed the girls, probably for something, for notoriety for the town, for more fame, money, whatever it might be. I really think that this was a sacrifice. And I do think that there's people involved that probably were close to the girls. Sorry, I didn't mean to go on such a tangent, but it irks me that these families can't see that. That these families are just like, no, he did it because the state says he did it, so he did it. And even though I sat through trial and testimony and didn't quite get convinced that he did it, the state's telling me he did it, so he must have done it. Is that their attitude? Or are they actually guilty or complicit in some way and they're trying to put the blame not on them? I don't know. It really is crazy, this whole case. And I wouldn't put it past any of the family members, is all I'm going to say. Where was I? All right, so I wonder, did he even think of our girls walking down the aisle? Our families will never get the privilege. The impact of Richard Allen's choices made that day has haunted our families for almost 8 years and continue even now. Because of choices he made in his subsequent arrest, he was appointed 2 lawyers. Okay, blah, blah, blah. Those lawyers have done nothing but twist the knife around and in our wounds that Richard Allen caused that day. Because of the lawyers' sloppiness, sealed crime scene photos of Libby's naked and mutilated body were left unattended. Not really, but kind of, allowing images to be taken and spread around to people on the internet. As recent as a week ago, these crime scene photos were still being shared on the internet for no good reason or for entertainment. I haven't seen them. I wanted to see them. I'll be the first to admit I looked for them. Haven't been able to find them. So wherever these images are, whoever's spreading them on the internet, it's not going anywhere. I haven't seen them. I have not seen them, and I've been looking for them because I want to look at them for myself to see what the state is saying happened versus what the evidence actually shows. I'm not scared to look at dead bodies. Like, it doesn't bother me. Touching one, yeah, I wouldn't want to do that, but looking at them, it's science. I feel the grief. I know for them it's personal because that's a family member that they love. For me, I don't know the girls. It's not personal. It's science. I'm trying to learn. I'm trying to understand the case better. And so for me, someone who was actually looking for the photos, I couldn't find them. But yet the prosecution, the media, and the judge, and apparently the family members of the victims all say that these photos are out there and it's terrorizing them. Well, where are they? I haven't seen them. And I looked for them. So how are they terrorizing anybody if they're not actually able to be found on the internet? I'm just so confused. Anyways, so I had to say that. As recent as a week ago, these crime scene photos were still being shared on the internet for no good reason and for entertainment. Sharing those photos changes nothing. It doesn't solve the crime. It doesn't bring the girls back. So now, because of Richard Allen's choices that day and his lawyer sloppiness, the impact has now become generational for us. One day, when Libby's nieces or nephews decide they want to learn more about their Aunt Libby, they may be forced or faced with the horrible crime scene photos that were so carelessly taken care of. I wonder if his lawyer would have been so careless with those photos had they been photos of his own children. Wow. He left them with a trusted colleague, and that colleague basically turned his back on Baldwin at the time. But that's not even besides the point. So there was that leak, but there was another leak by the state. Like, I really do think that there were many leaks by the state early on that were going on. And you got Dr. Walla talking to people in chat rooms. I wonder if his lawyer would have made that mistake if it was his own girls. Would he still have felt no accountability because he was snookered? And then you have the other lawyer who sat in the judge's chambers stating he really didn't care that the photos were released. I wonder if he would have been so callous and uncaring if those were photos of his child's naked and mutilated body being shared. Would he still not care? When does it ever stop? As recent as yesterday, the defense continued playing their games. They know law enforcement investigated their third party theories with never being able to place any of those people at the trails that day, but yet they continue their charade at the expense of Abby and Libby. We don't even want to go there talking about hardship caused to the families. Richard Allen is not the victim. Now, those professionals are allowed to claim no accountability for their actions and move on to the next case, disrespecting and devaluing the next victim's families. Meanwhile, our families are left picking up the pieces because of our choices and actions, because of their choices and actions. In the end, all these choices made by the defense team, the fallout our family now have to live with for generations to come. Okay, come on. This is so freaking dramatic. Falls directly on the head of Richard Allen because of the choices he made on February 13th. I could go on and on about what we lost that day, but it would change nothing. The deafening silence in the house, the milestones missed, the grandbabies never to sit on our lap, the impact Libby and Abby would have had on so many lives. Talking about it won't bring them back to us. Nothing in this world can change the outcome of that horrific day. No matter how hard we wish or pray them back, they're gone forever. Only Richard Allen, having made a different choice that day, could have changed it. Their lives were in the balance. He chose to kill Abby and Libby. Their lives mattered. He, Richard Allen, is the one responsible for all of this. All I can hope for now is that Richard Allen will be held accountable to the fullest extent of the law and what he did that day. His sentence needs to reflect not only of murdering the girls, but also serving time for each day of life those girls still had in front of them for every feat they may have accomplished. I feel he should serve 1 day behind bars for each future day he robbed from the girls. I hope that he's not held in a single occupancy cell since his attorneys feel it would be detrimental to his health. I hope he is ordered to reside in general population so he can have the human interaction he so craves and needs. You just want him to be taken out by other inmates, probably. Last of all, I hope he lives each day of the rest of his life living with the same fear he bestowed on Abby and Libby the last hour of their lives. I hope the choices he made on February 13th come back to haunt him, giving him no peace. I learned a long time ago, don't wish bad things on other people. That's what a lot of this is. I hope the choices he made come back to haunt him. I realize I should not feel this way, but I can't stop these feelings. I hope God can see my heart and can forgive me. Richard Allen caused this. I hope Richard Allen's new relationship with God will finally compel him to do the right thing and stop this nightmare from continuing any longer, not only for our families, but his as well. He needs to do what he knows God would want him to do. I hope he finally gives the girls the respect they deserve, give them back the dignity he so callously took from them. How? How is he going to do that? How? Richard Allen took so much from our families and the world that day, but what he will never take from us is our memories we have with Abby and Libby. We will forever keep them alive, even if it's only in our hearts. I live every day with the burden of the choice I made on that day by letting them go. I can never change the results of my choice of letting the girls go to the trails, and I take responsibility for that. What about you, Richard Allen? Will you ever own up and take responsibility for the choices you made that day? Only you can stop this nightmare for all of the families. You can make that choice. The court says, "Thank you, ma'am." Mr. McLeland says, "Judge, and lastly, the state would call Mike Patty. Please, will you state your name for the record? Please. Mike Patty. Will you spell it?" He does. "How are you related to the victims?" "I'm Libby. I was Libby's grandfather." And you have a statement you'd like the court to consider in sentencing, is that correct? That's correct. Go ahead, sir. All right. First off, everything that's been said here today resonates, kind of gives you a picture of what our families have been going through. Some of the stuff I've written down is going to repeat some of that, so I apologize, but all these things are coming from the heart from all of our family members, and the impact that this has had on our families. Honorable Judge Fran Gull, we appreciate your firm, fair guidance and direction, your ability to thwart all of the unnecessary noise. Does Judge Gull have relationships to the Patty family? We appreciate your firm, fair guidance and direction, your ability to thwart off all unnecessary noise and acts that were deployed during this process. All that stuff that the defense was trying to pull, all the shenanigans. It's not real. The Frank's memos and all that, the Odinist stuff, not real. It's just, thank God we had Judge Gull to thwart all of that off. Thank you for standing firm and staying focused on what needed to be done. I request you provide the maximum sentence allowed under our justice system, and whatever that sentence is, but also have no possibility of parole. There's no parole available for our girls. For this, I will never forget. Prosecution, we appreciate your willingness to stay on task, putting in numerous hours, putting the case above many of our personal needs. Your personal needs, sorry. The results speak for itself, and I wanted to share our deepest gratitude for this. I will never forget. The investigative team, we appreciate your determination and grit to stay on this for so many years. Is this like an acceptance speech? I want to thank you and you and you. I've observed and watched from the outside while you investigated so many tips that many have no idea about, all to deliver proof to get to the bottom of this case. Never once did I hear we're out of options. There was always a full court press to bring justice in this case. For this, I will never forget. To our family, I am so blessed to have a loving and welcoming family. Only wish I could have prevented any of this from happening, and I wish I could have prevented everyone from having to go through this. Our family is strong. We will march forward and continue to grow. For this, I am grateful. Defense, I understand the role you needed to play, but I cannot connect the ways of our legal system to allow so many things to interfere with the truth and the facts simply to be brought before a jury. This family is pushing so hard that the defense is pushing some kind of conspiracy theory or false narratives that it really makes me believe the family is complicit in this. They really don't want it to get out. The third party stuff. The families especially are fighting it. So what does that say to me? That says I think that's significant anyways. I cannot imagine our forefathers ever envisioned the attempts to suppress and divert facts that would ever be part of our justice system. One should reflect and review their position to support truth and justice. Your inept ability to protect some of the most personal facts in this case, the crime scene photos, and making statements you didn't really care that they were out there. I don't care either. It's not the end of the world. Crime scene photos have been out. I can't remember, or I can remember Nicole Brown Simpson crime scene photos being out, and those were like so bloody and vicious. I remember those. I remember the Menendez brothers crime scene photos being out in the media when this shit was originally happening. Now all of a sudden it's like, oh no, we're all just too sensitive. We can't look. I get it. Not everybody wants to, but sometimes if you don't look, you're too sheltered and you don't know what's going on in your world and you can't find out the answers. Anyways, one should reflect and review their position to support truth and justice. My family will forever have to explain how these are available for people to search the photos. What do I say to my kids, my grandkids, and my great grandkids? What will you tell your grandkids? I hope you tell them the truth. I surely will. For this, I will never forget. To the convict, I will never understand how you could have conducted such an atrocity. You killed my granddaughter nearly 8 years ago and have only thought of yourself. Your attempts of self preservation are a result of how you really are. Once you committed this crime, you could have been a man, stood up, and taken accountability, but you didn't. At any time during these proceedings, you could have stood up and taken responsibility, but you didn't. Doesn't that tell you something? That he didn't do it. Pay attention to the evidence, you dumb family. I'm sorry, but there's no excuse. You sat through a trial. There's no excuse. You're blinded by grief. I get it. But you got to look at the facts and the evidence. Actions always speak louder than words. By being so selfish, you continue to punish and hurt my family. For this, I will never forget. Your act of murder has tested my faith. I'm still not ready to provide forgiveness. Oh no. If I'm able to, it will be for my own faith and conscience, not for yours. For this, I will never forget. I never felt such hatred, and I know I should not be this way towards another human being, but what you have done has impacted so many people's lives. We will heal with the help of our pastor. I'm lucky to have a great family and will enjoy the rest of my life helping and watching all of them grow from our kids to our great grandchildren. This is something you will not get to take away and you'll never get to experience the joy and love as what my family has. Lastly, I hope the rest of your days are spent in as much fear as the girls had to experience in the last part of your lives, and hope those moments haunt you the rest of your days. You deserve no better. Now it's time to stand up and take accountability, put a stop to these future attempts for appeal. Just let the girls rest in peace. Don't appeal the case because new facts might come out. They might point to my family. So stop what you're doing. If you had a heart, if you were human at all, you would stop your appeals because my family might then be implicated. So just, don't appeal. Let the girls rest in peace. Whatever. McLeland says, "Thank you, Judge. The state has no other witnesses or no other family members that would like to make an unsworn statement. The state would just reserve its right for argument, and that would conclude the evidence the state has for sentencing, Judge." The court says you may proceed, Mr. McLeland. Mr. McLeland says, "Thank you, Judge. Judge, as the court can see from the victim impact statements in the pre-sentence investigation and from the statements made here today, Abby and Libby were very special to a lot of people in this community. They touched a lot of people's lives, and everybody that they interacted with, they left a last impression with those people, from teachers to principals to community members. They are caring, loving, selfless, and two special little girls. The family endured 6 years without knowing who committed this offense, 6 years of torture until Richard Allen was arrested, and at that point there should have been a sigh of relief for the families, but there wasn't. After his arrest, YouTubers called them names. Countless podcasters accused them of being corrupt. Yeah, I think that the family might maybe have something to do with it, and that's my opinion. I'm certainly entitled to it. This case gained nationwide attention, and when the crime scene photos were released, they were re-victimized by people sending them the crime scene photos or the crime scene photos being posted on various websites and web pages, all in an effort to get more clicks, to be a more popular site that someone would visit. So the families continue to be re-victimized even today, Judge, as the families heard them state. Even today, they continue to see these photos. This crime affected the community. It affected the community in a negative way. Many of the family members and many of the investigative team were born and raised in this community, and they can tell you that this was a quiet, safe little place to live, little town in Midwest America. After this crime, it became a place where people locked their doors, where people went and actively pursued firearm licenses to carry and conceal, where they took defensive classes. I'm sorry, but if you've ever, listen to any true crime anything, you should lock your doors. You should know, lock your doors. Small towns, big towns, it doesn't matter. Lock your effing doors. I have a thing with that. Just because you're a small town and no crime ever happens, that doesn't mean leave your doors unlocked. I'm sorry, but no. So they go on to affect the families. Did I skip something? I know, Judge. I know these aren't statutory aggravating or mitigating factors, but these are things to consider that Richard Allen's actions go far or well beyond what happened in this courtroom or what happened on February 13th, 2017. They go to the effect the families of the victims, the families in the community, Judge. I think it's important to show that throughout this sentencing, throughout the trial, Richard Allen seemed to show no remorse and no regret. Now, as a mitigating factor, he does not have any criminal history, and I concede that's a mitigating factor. However, the nature and circumstances of the crime greatly outweigh any mitigating factor that the lack of criminal history gives him. Judge, I know this was read during the trial, but I want to read the court a short excerpt from the entry of Dr. Monica Walla. This is an entry that seems to rattle around in my head days after the trial. States uh, Allen reported wanting to confess to his crimes and wanting to tell his story. He stated, I bundled up. Once at the trail, I laid in wait. I saw the girls and followed them onto the bridge. I ordered them down the hill. My intention was to R the girls because I thought they were older than their biological ages. He saw a van and got scared. Then I ordered them across the creek and I cut their necks. I wanted to make sure they were dead. He reported he covered the bodies and he walked back to his car and continued on his life because he hadn't been caught. He laid in wait. For some reason, that statement rings in my ears. To think that Abby and Libby are just out for a walk on a trail that day to take pictures to enjoy nature, and to think that he laid in wait for them and then approached them with the gun. He was right behind them in the video. How can you say he laid in wait? And then that's when he pulled out the gun and ordered them down the hill. I probably watched the video from Libby's phone 1,000 times in preparation for trial during the course of the investigation, and the fear in Abby's voice when she runs by Libby. I just can't imagine the fear that they both had at that moment when he reached them with the gun and said, girls or guys, down the hill. I've watched that video so many times. There was no fear. Once they're down the hill, he orders them to strip, 14 and 13 years old, to remove their clothes, expose their naked bodies. He began to assault them, but he was interrupted only to lead them across the creek and cut their throats. There's no DNA of Allen's on the girls. There is, however, male DNA on body parts of the girls, including their private parts that have never been identified. Again, I'm pointing to the family just a little bit. I'm kind of thinking maybe a little. Might have been going on for a while, even. I don't know. I just can't imagine what was going through their heads as he cut one of their throats and the other one had to watch while they're naked. I don't understand, Judge, and I just can't imagine. And then he walked calmly back to his car and he lived his life here in our community for the next 6 years like nothing happened. No remorse, no regret. This is a man, if he's allowed out, he will kill again. He's a danger to our community and he's the worst kind of danger. He's the kind of man that can kill two girls and then be so callous as to go on with his life like nothing ever happened. That is a dangerous man. So the nature and circumstances of this crime, Judge, in the state's mind, far outweigh uh, any mitigating factor or mitigating weight that the lack of criminal history may give him. And so, with that being said, Judge, the state's recommendation is a fully executed sentence on both counts consecutive to one another, 65 years for the murder of Abby and 65 years for the murder of Libby. The state would ask that those sentences run consecutive to one another for a total of 130 years in the Department of Corrections. The sentence only seems fitting for his actions on February 13th of 2017 and only seems fitting for the murder of Abby and Libby. Thank you, Judge. Any response, Mr. Rozzi? Judge, just briefly, that, the defense acknowledges that, this is a day for the victims' families to speak, and, the system affords them that opportunity. I do think, as Mr. Allen's counsel, that it is worth pointing out or asking the court at least to disregard the comments related to the actions of his lawyers throughout these proceedings to the extent that those comments would support an aggravating or mitigating, or I should say, an aggravating circumstance. I don't think that they're relevant for that purpose. So things that the attorneys did aren't shouldn't be used for deciding what how long his sentence should be. Basically, is what he's trying to say. Things that the attorneys did shouldn't affect his sentence. I don't have any problem with these people getting up here and speaking their piece, but to the extent that those would support an aggravator, I'm asking the court to disregard that comment. Thank you. The court says, Mr. Allen, is there anything that you would like to say to the court? No, Your Honor. The Court says, well, Mr. Allen, the record will show that you're here in person this morning with your attorneys, Mr. Rozzi, Ms. Auger, and Mr. Baldwin. The state is here by the elected prosecutor, Mr. McLeland, and his deputies, Ms. Diener and Mr. Luttrell. Having been found guilty following a trial by jury, you are now here for sentencing. Having considered and reviewed the written pre-sentence investigation report, the sentencing memorandum submitted by counsel, the victim impact letters that were attached to the pre-sentence investigation report, the testimony of Trooper Holman, Carrie Timmons, Josh Lank, Diane and Eric Erskine, Mike and Becky Patty, and the arguments of counsel, the court now finds the defendant guilty of murder, a felony in count 3, a murder, a felony in count 4. The court will order the convictions on counts 1 and 2, felony murder, vacated on purposes of double jeopardy. Huh? So he's not getting the felony murder, he's just getting the states counts, the state charges. Your attorneys, through their sentencing memorandum, have asked that I consider mitigating circumstances in your behalf. They have asked first that I consider that you have no criminal history, and that is, in fact, a mitigating circumstance that you have no criminal history. Candidly, I don't weight it terribly heavily, because you come into this court convicted of the most serious offense that the state of Indiana has, but you do, in fact, have no criminal history. Your attorneys have also asked that I consider that your imprisonment will result in an undue hardship on your wife, Kathy Allen. I decline to find that to be a mitigating circumstance. Any imprisonment imposes a hardship, and you've been in prison for quite a bit of time, but I decline to find that to be a mitigating circumstance. Counsel has also asked that I consider the non-statutory mitigating circumstance that you served in the United States Army National Guard for about 10 years, having enlisted when you were in high school. I decline to find that to be a mitigating circumstance. It has nothing to do with anything. And finally, your attorneys have asked that I consider your long history of mental illness. There was evidence presented during the course of your trial that you suffer from depression and anxiety, and that is, in fact, a mitigating circumstance. However, I do not count it. So all of his mitigating circumstances, I don't count. Because there's no nexus between your mental health history and the vicious crimes that you have now been convicted of. But there is a nexus to his mental health and confessing. So there's a big difference there. Anyway, she says, so I decline to find that to be mitigating circumstance. Although I do recognize your mental health history, but there is no nexus. Those are all of the mitigating circumstances that have been advanced by your attorneys. I do find aggravating circumstances in the nature and circumstances of the crimes that you've committed. I don't need to go into a lengthy recitation. The record speaks for itself. I've been a criminal court judge for about 27 years, Mr. Allen, and I presided over some of the most hideous cases in the state of Indiana. You rank right up there with one of the most hideous cases that I've presided over. The nature of the crimes that you've committed and the impact of your crimes on this family are astonishing. You have multiple victims, and that is an aggravating circumstance that justifies consecutive sentencing. And I find as a specific mitigating circumstances the extraordinary impact on the families of Libby and Abby. You know, the legislature assigns terms of years in their determination on what sentences should be. So the maximum or minimum sentence is 45 years, the maximum sentence is 65 years, and you rank right up there with the extraordinary impact of those families. And not just the specific family members that testified, not just the specific family members that submitted victim impact statements to this court, but I think it was Libby's grandmother who talked about generational impact, which far exceeds that which the legislature have determined to be significant. Candidly, I've never really thought about generational impact, so I appreciate the opportunity provided by Libby's grandmother to consider that. These families will deal with your carnage forever, and you sit here and you roll your eyes at me as you rolled your eyes at me repeatedly throughout the course of this trial. Petty Gull. She's a petty Gull today. The court would find that the aggravating circumstances are such that they require the maximum sentence consecutive. The court therefore orders that the defendant be committed to the Indiana Department of Correction for classification and confinement for a period of 65 years on count 3 and a period of 65 years on count 4. As there are multiple victims, the count or the court orders that those sentences be served consecutively for a net of 130 years. In the Department of Correction, give your credit for 786 days served in jail in pretrial confinement. Assess the public defender fee and court costs and enter judgment accordingly. Mr. Allen, you've heard the judgment of this court pronouncing sentence. Pursuant to Criminal Rule 11, I would inform you you are entitled to challenge both the convictions and the sentences. In order to do that, you have to file a notice of appeal with the Clerk of Court of Appeals within 30 days of today's date. If you fail to timely file that notice, you forfeit or give up your rights to appeal. They ask for additional time, but they've already put in their appeal. The state has responded, and then Allen has again responded to the state, and we're waiting to see if federal court is going to hear any oral arguments on his appeal right now. If you cannot afford an attorney, I will appoint counsel at public expense for the purpose of filing the notice of appeal and appealing the conviction of the sentence. Do you have any questions concerning your rights to appeal? No, Your Honor. The court says, will you be hiring an attorney to represent you, or do you need me to appoint one? Just appoint, Your Honor. All right, I will appoint the public defender of the state of Indiana to timely perfect your appeal, and I will send the notice of the judgment of conviction to the state public defender so that he may begin the process. Is there anything else on the record, Mr. Rozzi? No, ma'am. Mr. McLeland. Judge, I did file this morning a motion to seal and keep confidential the crime scene photos and the autopsy photos and the reports. I printed the court out a courtesy copy. I apologize, I did not get it done until early this morning. With the continued, exhibits of the crime scene photos on the internet, the state's made the motion to seal those things permanently, the crime scene photos, the autopsy photos, and the autopsy photos also the mental health and medical records of Mr. Allen as confidential. I think that's appropriate under the statute, Judge, that I cited. I think those are exceptions under IC 51434 that can be exempt from FOIA and exempt from distribution. I want to make sure that the families are not continued to be re-victimized. This case is over. If anyone related to this case decides to release those autopsy photos or the additional crime scene photo or mental health records, I think those things are privileged. I'd ask the court to consider. I understand the court may not be willing to make a ruling on that today, but I wanted to bring that motion to the court's attention. Mr. Rozzi? Judge, I appreciate Mr. McLeland's thoughts in that regard. I did catch that motion as I was leaving the office this morning, so the defense is not conceptually burdened or troubled by those requests, but if the court would give us 7 days to just take a look at the statutes and the case law that's cited, I would appreciate that, and we will file a response. I think it'll be brief, but I'm not familiar with the statute and the specific case law that's cited. So I'd like a minute to shepherdize those. Okay, that's fine. Yeah. McLeland says, nothing further, Judge. Thank you. Court says, and based now on the conclusion of this case and the trial, the gag order that was previously issued by the court back in December is lifted and counsel and the parties are relieved from the further responsibility. Thank you much. Thank you very much, counsel. Thank you, Judge, says McLeland. Thank you, Judge, says Stacey Diener. The court says the defendant is committed to the Department of Corrections, and that concludes the sentencing procedures. So there you have it. In 4.5 hours, we went through jury instructions, both closings, the verdict, and the sentencing. So Richard Allen is, as you know, he was found guilty. Whoops, what did I just do? I clicked on the wrong thing. So Richard Allen was found guilty, as you can see, and sentenced to 130 years in prison, 65 consecutive sentences. We have, like I said, they're waiting on oral arguments to hear from the federal courts if they're going to be able to do oral arguments on their appeal, which hopefully they can. The appeal is really strongly written, as is the response to the state after that. So we shall see what happens. Hopefully, he gets a new trial or just vacated altogether because what the state did to him is egregious. Again, I'm going to leave out a poll that's going to ask you if the state proved its case. Now that we've read through all of the testimony, to you, did the state prove its case beyond reasonable doubt, or even maybe a little bit of doubt that maybe he did it? Or are we just all on the team Richard Allen, we got to free him? That's kind of where I want to see where you guys land after reading through all of the transcript material. Before I go, quick announcement. So I am not going to be starting a new trial to replace the Delphi trial. We are going to extend the Menendez trial to 3, maybe even 4 episodes per week. I really want to try to get through it a little bit faster. We have a lot still to go, so I am extending that to the Menendez brothers trial, which we will get through probably in the next Probably in a couple months because there's still like 90 something episodes I have to record to get through. So that's what we're going. You guys voted anyways, so that was what you guys wanted, was to extend Menendez, and then when Menendez is over, we can pick another trial or not, whatever you guys want to do. So just wanted to give you guys that update. Thank you guys for writing this journey with me in the Delphi case. It's been a crazy one. I'm still 100% convinced Richard Allen is innocent, railroaded, framed, whatever word you want to use. I don't think he did it. Let me know in the comments below if you think he did it or not, or if the jury got it right. Let me know. Bye, guys. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.